Introduce Jerry Lees too, please, Chair. Thank you.
Hi, okay. Welcome to the second hearing for the inquiry into the integrity of the New South Wales Biodiversity Offset Scheme. The inquiry is examining a range of issues, including the effectiveness of the scheme to halt or reverse the loss of biodiversity, the administration and regulation of the scheme, and the use of offsets for major projects. Before I commence, I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land on which Parliament sits. I also acknowledge the traditional owners of the lands from which all meeting participants join us today. I pay my respect to their elders past, present and emerging, and extend that respect to all Aboriginal people watching. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being held virtually and in person and is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about your comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it's important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness can only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days of receipt of the transcript. Finally, a few notes on hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to, and could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking, and members and witnesses should please avoid speaking over each other so we can all be heard clearly. I now welcome our first witnesses. Could each witness please state your name and position title and swear either an oath or an affirmation? I'll start with you, Mr. Lees.
My name is Jeremy James Lees. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And Mr. Buffier.
Thank you. Barry Desmond Buffier. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much.
I'm here in my capacity as an advisor to FAP nominees.
Okay, thank you. And one of you or both of you making a short opening statement?
I'm making a short opening statement.
Please proceed.
FAP nominees was issued 52,168 TJ BBAM credits when Biobank 393 was set up in July 2018. In the agreement, the OEH stated that the total value of all issued credits in the Biobank was $5.84 million, and FAB calculated that the value of the 52,168 TJ BBAM credits was $5.55 million. FAP were advised by the DPIE to use the spot price index as a guide to the value of the TJ BBAM credits. In August 2020, this was $160 per credit for a total of $8.34 million. When the Threatened Species Conservation Act was replaced by the Biodiversity Conservation Act, a policy of reasonable equivalence was introduced for the protection of investors in the earlier Act. FAP believes that the policy of reasonable equivalence equates to reasonable financial equivalence as well as ecological equivalence. In late August 2020, the OEH and the BCT Biodiversity Offset Program team advised FAP that their 52,168 TJ BBAM credits were equivalent to 66 TJ BAM credits, and that their value was a minuscule $9,390, a loss in value of 99.9% of the 8.34 on the spot price quoted. We have never received an explanation as to why the BCT offered FAP a price of effectively 18 cents per BBAM TJ credit, whilst in the public arena, the government was quoting $160 on the DPIE spot price. FAP nominees holds more than 50% of the issued BBAM TJ credits in New South Wales, which means that a developer could buy all the TJ credits in New South Wales for less than $20,000. At this value, the cost of setting up a biodiversity site to protect the TJ species would be a financial disaster. FAP complied to the BCT and the DPIE and met with staff at executive manager and CEO levels seeking restitution and compensation. As no satisfactory progress was forthcoming, in January 2021, FAP submitted a claim for compensation to the New South Wales Ombudsman. This investigation is ongoing, and the details of the complaint are included in our original submission, number 41, to this inquiry. In October 2020, FAP engaged the services of an international arbitration expert, Mr. Charles O'Neill. He has provided us with his opinion. FAP has provided to Mr. O'Neill the documentation that accompanied the letter to the Ombudsman and other information he requested. This information is attached to his opinion. I quote his findings from the opinion. My independent opinion on FAP's proposed compensation claim. I find that the government has not complied with its own legislation as in breach of the contract in 3 respects. The actions of the DPIE and the BCT did not comply with requirements of the Act. The actions of the BCT and the DPIE have prevented the FAP agreement being performed as contemplated by effectively destroying the free market pricing and trading of BBAM TJ credits and reducing FAP's investment in the TJ credits by 99.9% from the published SPI price of $160. At the same time, eliminating the financial incentive to protect the BBAM TJ species. The primary cause of this was that the government ignored the financial and commercial aspects of reasonable equivalence regulations. In respect of FAP's proposed compensation claim, I find that the evidence substantiates and justifies FAP's proposed claim for compensation and that the compensation should include the following sums which are appropriate for breach. I find that FAP's claim, based on a valuation of 52,168 TJ credits at $160 each, being a total of $8,346,880, is justified. I find that the interest on the original invested sum at the statutory rate applies, dating from the 31st of July 2018, and that all legal and related costs for both parties should be paid by the BCT. On the 25th of November, this expert opinion was provided to Dr. Paul Grimes, Coordinator General of Environment and Energy Science in the Department of Planning, Industry and Environment, with a request for a meeting to discuss the issue of compensation. Dr. Grimes responded on the 3rd of December, indicating that he would await the completion of the Ombudsman's consideration. FAP has been seeking restitution and compensation from the BCT and the DPIE since September 2020. We believe we have been victims of the bureaucratic runaround. We ask that the government and the upper house assist us in swiftly bringing this saga to a conclusion. I ask leave of the committee to table Mr. Charles O'Neill's opinion.
Thank you. Yes, we have leave. I would suggest to do that.
Good. Here we are.
Thank you.
In copies there. Thank you so much.
Have you finished your opening statement, Mr. Lees?
I have,
yes, thank you very much for that. We will now go to questions. Mr. Buffer, you don't have an opening statement as well.
Thank you.
We'll go to questions from the opposition. Ms. Penny Sharp. Thank you.
Thank you for that. I am interested in what is the current status of the Ombudsman's inquiry?
That's a very good question. He told me 2 days ago that they were meeting with the DPIE and that he would ring me and tell me what had happened, but he hasn't done so far.
So obviously he'll meet with them and then there'll be some sort of report. I mean, what's your sort of expected timeline, or you just don't know?
Well, it's been a year or so far. Look, he's been extremely pleasant to deal with, and he tells me things like, we've got to take due process, and I say, well, it's pretty straightforward. We have tabled Mr. Charles O'Neill's opinion, which we gave to Mr. Grimes, and we also gave a copy, naturally, to the Ombudsman. I'm hoping something's going to happen.
Could I just comment that the Ombudsman's made it very clear to us and the department that they don't need to await any final position from him in order to come to some agreement on this issue, that they are free to negotiate with us outside of that process, and I think he would welcome that, has been the impression I've had. Jerry?
Yes, I mean the Ombudsman's an interesting vehicle to be pursuing the issue of compensation. I mean, that's, normally that's not really their role. Their role is to just oversight the administrative aspects of how this issue has come to pass, clearly a significant one.
This goes to the issue of maladministration in the department, and the maladministration relates to the equivalence process and the changes that were instituted in the scheme in moving from one scheme to another, and the prices that are offered in the market. So initially we've been trying to get the department to respond to those issues, and they haven't responded. So we're now at the point where we've assessed what the compensation would be due.
Perhaps I could comment on that. The Ombudsman was very clear with me when I first put my submission in, and you have a copy of the total of the submission which we've tabled to yourselves, right? Not this, but before. And he said, look, we're not here to look after, but we're here to see if the people in the BCT DPIE have not performed correctly, right? And if you just give me, we need to. So they went away and found it, and then they came back and yes, we agree that this is a case we should take on. And then 6 months later, after we provided a lot more, they said, well, the case has now been relegated upwards to a significant case, and that was 2 months ago. And as I say, they have met again, but I don't know the result.
I mean, look, the whole thing is, points to many problems in the process, the changeover, obviously. I'm just wondering if you could, I was particularly worried about the fact that online the spot price says one thing and yet three days earlier you were told it was worth something else.
Not the spot price.
Yes.
No.
The BCT spot price on the 30th of August,
yes,
you say in your submission,
yes,
basically said your credits were worth about $8.34 million, but you're saying that 3 days prior the BCT advised that the changes had been made, but can you just take me through that process?
Yes.
Like how you found out, and
yes,
it's curious to me that would be, that the online price says one thing, but you were told 3 days before.
Just prior to them advising of that price that you're talking about, they sent me an email, which I'll just look at the dates here. Sorry. Okay.
It was the 27th of August, I think.
That's right. Yep.
On the 23rd of July, right?
That's the email there, Jerry.
Better get this right.
That's the email there.
Yeah, that's right. No, but that's not the one. Okay, on the 23rd of July, we received an email from Vanessa Owen of the BCT, giving us the new TJ equivalents. And that was the one where they changed the equivalent from 52,000 credits to 66 new credits, right?
Yep.
On the 30th of July, we received a Somewhere I've... Oh, sorry, I've got that wrong. I'm sorry, that's it wrong. On the 27th of August, we received a letter from Claire Kerr of the BCT Programs Department, and they said that we've been successful in selling some BAM credits to them, and that gave a price per BBAM credit of 18 cents a credit.
Yep.
Right? So that was on the 27th of August, right?
Yes.
In the same time, the BBAM spot price, which we've been told to use by Lucy and Macarone, was $160.
Yes.
Yes. I don't know
So
why.
I'm just trying to understand, this is what I'm trying to understand. I'm trying to understand how you're getting advice on one hand that says that it's 18 cents, but publicly the price is $160.
I think it'd be fair to say we're still trying to understand that too. We are absolutely incredulous that you could have a price in the public arena of $160, a BBAM credit, and we've provided copies of that, and then in the same week get something saying we're offering you 18 cents. I mean, it defies logic.
And, I mean...
So we are at a loss to... we haven't had an answer to that
that's essentially
question.
what the Ombudsman needs to unpack, really. I mean,
Yes.
I'm assuming, I mean, just playing the devil's advocate here, I assume that the government would just argue that they'd made the change, but they hadn't updated the website?
Well, it stayed at $160 for many months, I think, didn't it, Jerry?
Yes. The $160 is the price somebody paid for the last price that was paid for TJ credits, the BBAM credits.
And then became 18 cents. Someone paid 18 cents. Is that what
No, they're offering 18.
Oh, no.
Offering the equivalent of 18
cents is the price they've calculated.
It wasn't a market price that had been offered to you.
Oh,
No, but this was an offer from the BCT, 18 cents.
Yeah.
So what we're saying is the last price in the market was $160.
Got that, yeah.
In the same week, the price that is offered by BCT, when you bring it back to a BBAM equivalent, is 18 cents. Now, did nobody look at what was available as the last price, and where did that figure come from?
Yeah.
So did you get any explanation at all behind the decision-making process to firstly halving the number of BBAM credits? Firstly, you said it was quite an arbitrary figure. Did you get any explanation from the department as to why?
no.
We think that was a mistake, don't we? The
They said it was
26,000.
something to do with equation 6, but I have no idea what it is.
Did
I'd like to read you an email I sent to Vanessa on the 30th of July. Right?
Sorry, Vanessa who? You just need to explain.
Vanessa
Vanessa
Howard
Owen
at the BCT?
Yes.
Yeah, good, thank you.
Your email of the 23rd of the 7th has reduced the number of TJ credits owned by FAP nominees from 52,000 to 66 BAM credits. Using the calculator, this effectively reduces the value of FAP nominees' credits by $5,670,427. Obviously, we can't agree with this and we do not accept your action. Whilst we've been disappointed with the equivalency process, the lack of consultation, financial impacts on the viability of the site, we accepted the Environment Agency head determination of reasonable equivalence for biodiversity credits issued with the biodiversity statement of the 26th of June for 26,084 BAM TJ credits in accordance with clause 19 of the Biodiversity Constant Regulation. We now further advise the equivalency is now 26,000 has disappeared and is now 66. This was made without any consultation or any clear justification or revision, particularly as this species was an area species at the time of initial reasonable equivalence provided in June 2019. Whilst we understand the Environment Agency head could make the equivalency under the BCT 2016 BC Regulation 207 transition arrangements, there is no reference to the Environment Agency head having the powers to apply multiple revisions to equivalency assessment it provides.
Thank you, Mr. Lees. Can I just suggest that you table that? It's going to be a lot easier for the make a copy rather than read out all of the technical jargon.
I'll table this and the other.
We've just got limited time.
I've got more. Yes.
So essentially, the BCT officer was expressing concern in that email about what the department or what was happening within the department itself. Is that
No.
right?
I never got any reply. You'll see the
we expressed
replies are there. We never
Was
got
that an
any.
email from Vanessa to you, sorry, or was that you to Vanessa?
That was Terry to
Vanessa just advised me.
Okay, sorry.
Right,
That's,
yeah.
yeah.
That was my reply to her.
I've just one last question before I throw to other members. So the species that you, the common name for it is the threatened species black-eyed Susan. Does this suggest then that either the department has given up on protecting it and just doesn't see it as valuable to protect it anymore? This may be a policy decision in some ways, but it doesn't seem financially feasible now for any landholder to work to protect the black-eyed Susan under the state's biodiversity offset scheme.
We agree.
Yeah. Okay.
But we don't think that. My own feeling is they didn't think it through what they did. They didn't have any. They made no attempt to look at the financial equivalency. They thought that they would just give it a bit of a change in area measurement. It turned out to be a number called 66, and they sent that off to me without even thinking of the implications.
As a
Pretty sure that's
species,
what happened.
as a species, it's still classified as a vulnerable species.
Right.
So,
The species is, destroyed.
so you would assume that the intent is still to protect it.
Thank you. I'll just move to questions from Mr. Justin Field and just welcome you as well, Taylor Martin, who has just joined us online as well.
Thank you, Chair. Just confirm, Chair, you can hear me?
Yep. Yes.
Thanks, Mr. Lees and Mr. Buffier for being here today. My first question, you note in your submission a loss of 99.9%, substantial, but have you realised that loss yet, or are you still holding the credits?
At this stage of the day, we're still holding all the credits. However, the BBAM credits are now probably useless because all new projects containing tetrathetic juncture will be assessed under the BAM credits, right? And it's obvious to us that the Transport for New South Wales tender, which just finished a while ago, which was for a new extension to the freeways in Newcastle, was the last large project that needed BBAM credits. So any new projects will be BAM credits. And that, of course, means that all of my 52,168 credits are now worth 66, according to the BCT DPIE. So effectively, we're holding them, but, we don't know what to do with them now. The whole thing has become almost a goodbye for them. And effectively, we would never have entered the biobanking system if this had been apparent. And we entered the biobanking system in 2018, and they apparently brought in these regulations that brought this about in 2016-17, but we were never told. We were never approached by the government, by the department to say, oh, by the way, do you know this is going to happen? We didn't know until when we got the equivalency in August 2020 that, oh, really? First it's 26,000, then it's 66.
Jerry, could I just comment on that particular question, because I think it goes to the heart of the matter about the scheme. The scheme is a very complicated financial investment scheme, and in any other environment, it would only be available to sophisticated investors, would require a product disclosure statement attached to it. There's nothing in here that warns the investor about the potential problems with this scheme and the multi-million-dollar losses that are possible, which is bad enough for the investor, but the implication also goes to the species. As you can see here, there's absolutely no incentive to protect blue-eyed Susans. None.
So just to be clear though, that's based off the 18 cents figure that you've been quoted. But what was the last sale for credits of this type? What was the last sale price?
Sorry, it was more than a price that was quoted. It was a price that was offered buy BCT, to buy credits, okay?
You don't need to sell it.
No, agreed. But here is the government standing in the market offering 18 cents. So, what message does that send to the market? But I think Jerry can answer for the next question. There has been a tender.
Yeah, the 18 cents is a calculation, and it goes like this.
I think just answer the question about the latest tender. Okay?
Yeah. Well,
because we
first of all,
a lot of time.
the $160 S spot price index was a real price paid by somebody for TJ credits, right? That's how that goes. However, the 18 cents comes from the fact that the calculator being used by the DPIE for BAM credits gave the price of one BAM TJ credit as $143. When we got our equivalents, that our 52,168 credits equals 66 BAM credits. So if you just do the mathematics and divide the 143 by 52,168, you get 18 cents. That's where it comes from. Yep.
Right. So they didn't send you a document saying, here's, an offer for 18 cents.
Yes, they did.
This comes about
Yes,
the result of the
Yeah.
calculation based on the equivalents.
No, the BCT made an offer to buy 40,000.
No, not 40,000.
To buy
yes.
the equivalent of 40,000 at 18 cents each. That's the offer they made.
Yeah, you have that in your.
We're speaking over each other a bit. Yeah. That means Hansard gets nothing when that happens. Yeah. So, Justin, did you just say something that you wished to have on Hansard? Because we didn't catch it if you...
No, I was trying to ask another question, but I realised I cut the witnesses off, so I stopped. I do have another question, though, unless there's anything else you wanted to add.
Just one more, and then we'll go to Ms Cusack, if that's okay. Yep.
So I am interested in what drives people to get into the scheme. Your submission suggests that, if I'm reading it correctly, you got into it basically because you identified land that was on the market for less than what the value of the potential credits on that site were, what the credits on that site were valued at by your consultant. This was a straight commercial undertaking for you. You found some land that you thought the credits were worth more than the price of land, so let's snap it up and enter the investment market here. Is that right?
No. In my submission to yourselves, it's all laid out there, but myself and 5 other superannuants loaned money to a company which went bankrupt. The only asset it had was this land, and we held a second mortgage on this land. So we were trying to get our $2.64 million back somehow. I went to Lake Macquarie Council. They suggested, why don't I consider a biobank, because they knew that the land had good prospects for threatened species on it, right? So then I hired Wally Parsons, in those days Parsons Brinkhoff Consultants, and they produced a feasibility report, which I have here, and that showed that there was a potential, it was worth a lot of money, certainly enough to encourage us to continue and spend another $800,000 or so getting the biobank set up and running, right? So that's how it happened, right? We didn't snap up a bit of land. We were forced into trying to make...
Thank you. We'll move to questions from the government. Ms Catherine Cusack.
Thank you very much. Yes, just following on from that, and just to understand this correctly, when you say the cost... Pacific Alliance Finance, it says the cost to you was $3.4 million for the land. Did that comprise... How did the debt that you had to the former owner relate to that $3.4 million? Is it in that number, or is it net of that, in addition to that number?
We had lent Pacific Alliance Finance $2.65 million.
Right.
They went broke. Unfortunately, the owner was blown up in the Bali bombing, and they did some things, and the other directors went to jail. So it was in receivership, right? And our only asset left for our investment was a second mortgage on the property, that whole Red property, right? So that's why we investigated, well, can we get any money back for this property? And the answer was, because it was zoned environmental, we could not build the housing, etc. And there'd been a big land case about it, and that's all in the stuff that you've got. And so the head of the department at Lake Macquarie Council, as I said a moment ago, suggested we might consider forming a biobank. And that's what we did.
Right, so did you purchase the land? Did you pay additional money for the title of the land?
We had to buy the first mortgagee out.
And how much was that?
Another $200,000.
200. So you had loaned them 2.65 million, but the value of the first mortgage was only 200,000.
That's what he would take for it. Right. We had to make an offer to the first mortgagee to have him to sell to us so that we could own the land so we could form a biobank, right?
Oh, but if
we then had to buy the land as well.
How much money was he losing out of that?
Beg your pardon?
How much money was he losing?
Was he losing?
Well, he's the first mortgagee and he's relinquished his rights to it for $200,000. So I'm confused by that.
The first mortgagee was a person who owned a huge amount of land in the Reddit area, right? And I'm wondering how I could put this. He just wanted to get rid of the land. We said, we'll buy this from you. How much do you want for it? He said, I'll sell you the first mortgage for $200,000 because he knew we had the second mortgage.
Okay, so how much money were you out of pocket then in total?
Oh, you mean for the whole biobank and everything?
The cost of the investment that went bad and then the $200,000, what does that add up to?
$2.8 million.
$2.8 million. So in your submission you say that the cost was $3.4 million.
The rest is the formation of the biobank, the thing, plus the trust fund deposit, plus everything.
This advice that you've received, which is attached, I'm not sure if I've got all of the advice. There seem to be a blank page, but I'm not quite sure if it's all of it. But it seems to be indicating that the credits have a potential value of up to $17.5 million.
Correct.
Right. So you were hoping to turn that loss of $3.4 million into a potential windfall of up to $17.5 million?
Correct.
Yeah. So would you describe this as speculative investment? On the basis that you're in a bit of a corner?
The minimum price they put on was 12 million. That was their minimum. This is these people who wrote this thing for us, Parsons Brinkhoff and those were the premium consultants in this area in Australia. Mm-hmm. We didn't think it was speculative at all.
Yeah.
But they do talk about potential and they do give a fairly wide range, and it's not clear to me that they're saying the onus is on the biobank to actually make the offer. I thought it appears more to be about the market for offsets.
Yeah. Could I just comment on that?
Please.
So when the agreement was signed, OEH calculated or estimated the value of the credits to be $5.8 million. Okay, so when they entered into this agreement, that was an expectation created by OEH. So the $17 million was, yes, the upper end of what might be possible, but in terms of signing a contract and entering into a biobank, it was largely based on the reliability of that estimate of $5.88 million. For that to become $10,000 at a price offered by the government is beyond anyone's expectations of an investment.
Can I just ask you, how long have you been involved as an advisor on this project?
12 months.
Right, so this was already a bust when you stepped in to give the advice. Okay, so in relation to the big problem here is the consultant's advice initially that had those numbers of up to $17.5 million. Have you taken this up with the consultant? Because I don't understand how this advice is the fault of the government.
Many times. Yeah. They're pretty horrified as you know from the attachments to the submission, they are one of the main consultants that wrote the letter to the government about the poor performance of the new schemes.
I do understand that, but it appears, I'm not sure that you have any background in environmental. I know that Ms. Buffy does, but so this, it just seemed like a scheme that didn't work out for you, if I can put it like that, in terms of the market. It doesn't say here that the government will be obliged to purchase these credits from you at that value. It appears to be implying that other developers in the market who are looking for credits, that they could be valued up to that amount.
Yes.
But it's just a valuation. It's not a...
No, well, it's a little bit different
And the fact
to
that there's no kind of... When you're into financial speculation, the fact that the disclaimers, the prudential management of the scheme, I think, the prudential supervision of the scheme, I think that's a really valid thing for us to be considering here,
yes,
just in terms of disclosure.
So the key question...
But we're trying to investigate the effectiveness of the scheme in relation to the environment.
So maybe you could ask the operators of the scheme why, when the last price for BBAM credits was $160, they came and offered to buy 4/5 of what was owned by FAP nominees for the equivalent of 18 cents. The government creates that market. That was the price that the government offered. So why would you destroy a market and then say, oh, bad luck, investors, tough titties, just take what you get.
Mr. Buffy, what was the project again? Like, was it a particular project, that was being offset in terms of where was the Black-Eyed Susan being cleared?
We don't know.
Is it more convoluted than that?
We don't know for that one because this was money that was acquitted to the BCT, and the BCT was wanting to buy some credits.
They only wanted to buy
so they offered
246 credits.
But to me, it looks like you're really dreaming that maybe you could get $17.5 million of money for the environment.
No, but he did think $5.8 million was feasible.
For an outlay of about $3 million. I mean, to me, that all by itself is of concern.
No, it's the estimate from OEH was $5.8 million.
We were trying to get back. We are all superannuants, nearly 80 years of age average. We were only trying to get back our $2.65 million. That's what we were trying to get back. All of this other thing just assured us that there was a large cushion, that we had a good chance of recouping our money.
Have you offered to settle it with the government for that amount?
We haven't had...
Can't get to talk to them.
The government hasn't even decided to slightly talk to us about anything.
Basically, now you're stuck with land that can't be developed, but you knew that.
Yeah.
And
so we are awaiting the
Ombudsman. Biobanking agreement.
that's it.
Okay, just questions, Mr. Pearson and then Mr. Mallard.
Just a simple question. Are there any other companies, or is there another company that has contacted you or wanting to join you in this action for similar reasons?
No.
I'm aware of any other company that's facing this predicament?
I'm surprised, but I don't think... There are 5 owners of TJ credits, issued credits, right? We're one. We own more than 50% of them, right? One is Lake Macquarie Council. They don't want to sell theirs because they use it to offset other things they buy. There are therefore 3 other people. One of those is I know, they just sold some of the credits for less than $10 a credit, which I think is remarkably what's happened to the whole market for TJ. And I think the other 2 probably don't know this has happened. There's not the whole selling of credits thing is not vibrant. You need somebody to come along with a big project. And our credit...
That's the risk that you take,
Our consultants, Pastor Briggo, were quite telling us this could take some time to sell, but don't worry, you'll sell them in the end.
Oh, gosh.
But now they've changed the whole thing and there's nothing to sell.
Crazy it is.
All right, I think Ms. Sharp, yours was answered.
Well,
is that
no,
right,
I
Shane?
mean, just follows on Mr. Pearson and follows on Catherine's questions. I just wanted to ask, are you aware of this sounds like a litigation matter to me. Have you started any litigation on this issue?
No, we're relying on the Ombudsman.
Ombudsman, okay, that's unusual.
Yeah.
And secondly, and I think you've answered it, I'll just make it clear that Mr Pearson asked the question, are you aware of other investors in other funds in this scheme with similar grievances?
No, I don't think so. And I think the problem is that we're such an outlier. You know, we have an enormous number of credits. And I think that's... And also, I think it's what's been very unusual is that we received from the government an offer to buy them, which gave a price that was so ridiculous that, you know, that stirred it all.
But I think we are aware. I think we are aware that there's violent fluctuations in the prices in the scheme.
All right, I think
Which are not disclosed.
Just to mention that the other credit owners are listed as Orica Australia, Cape Otway Proprietary Limited and Lake Macquarie Council.
Yeah.
thank you. I think Ms Sharp, or you finished, Shane? You can,
Yes, I just wanted to
Ms Sharp.
Yeah, I mean, look, my final question is really about the advice that you were given, the timing of this. I mean, the law had already changed. We'd gone from the Threatened Species Act to the new Biodiversity Conservation Act, and there was going to be a change in the way in which credits were applied. Do you know why the original advice didn't really pick that up? You're just relying on the fact that the spot price was there in terms of the calculations of what potentially it would be worth. I'm just trying to, the missing, having unpacked a bit of this now, one of the missing pieces to me seems to be that it was clearly a change in the law. No one, and I accept that real issues around transparency and understanding what that would mean. But in terms of the calculations that you were relying on, they didn't seem to pick up the fact that the law was changing.
We were unaware of the spot price until after all this happened, and Lucian McElwain from the DPIE sent us an email saying, oh, by the way, the spot price is the most reliable area for prices for TJ BBAM credits, and that's when I went there.
But that was BBAM as opposed to the new BAM.
Correct.
That's the bit that is clearly been, that decision point has completely changed the assumptions that you had in terms of what was going to happen.
But I think the key point here is that this issue of equivalence. So yes, they might have been BBAM credits, but when you talk about an equivalence in BAM credits, there's an expectation that equivalence is equivalence. And there's no way in the world that the change that occurred from 52,000 to 66 represents anything like financial equivalence or any other form of equivalence. So, yes, they might have entered into it under the old
view is
scheme.
the government's arguing that the department would argue, not that this has been litigated yet, but the equivalence is not a financial equivalence in terms of people.
Well, they might argue
land.
that,
It's the environmental equivalence.
That's not the view of the arbitrator that was appointed.
Well, no, I'm just looking at that, but I just want to be clear that's where we think this is going. Okay.
Yeah, but leaving that aside, if you look at 52,000 equivalencing to 66, and they say that, well, you will adjust your price per unit, it would have to be $120,000 per unit to even come close to what it was before. So the key question is, why did the BCT destroy the market so drastically in offering a price such as that?
At any stage, did the BCT or departmental officials visit the property?
No.
Or is it just GHD who did the on-ground assessment?
Well, they must.
Yes, because they would have. They were on the property with the consultants.
But
and
the
they
BCT.
did the initial, yes, counting, etc. Yes.
That would have been OEH,
yes,
wouldn't it?
Yes.
Jerry? That would have been OEH on the property, not BCT.
Yeah, I'm not too sure whether it was OEH or BCT who were there, but certainly when you go to get these things credited, there are representatives from the proper department that will credit that. And there was an argument. Our consultants thought there'd be 69,000 credits, and they were forced to agree that they could use 52. So,
but there was some on the ground truthing of what was there and that this species was there.
Yeah, OEH had said 5 million at the time.
5.88, wasn't it?
The value of general days land at $1 million or something, I think.
Or I might
to you.
need to leave it there if that's okay. Did you have one last pressing question, Catherine?
No, I'm sorry.
Okay, no, that's okay. All right, so certainly something to pursue potentially with the BCT and the department. So thank you very much for appearing. I don't believe you took any questions on notice. So
No, we didn't.
Thank you very much. The Secretariat will be in touch if there are any supplementary questions for you.
Thanks very much.
Thank you so much. Welcome our next witness, if yes, we are ready to go. So welcome Mr. House. I'll just get you sworn in if that's okay. If you could please state your name and position, title, and swear either an oath or an affirmation, which I understand you should have.
Yes. My name is Stephen House. I'm a director of Meridolum. I'll take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr. House. Now, do you have an opening statement to make for the committee?
I do, yes.
Please proceed.
Firstly, I would like to pay my respects to the Gadigal people on whose land we are located, and to elders past and present. I'm a director of Meridolum, which was established in 2017 to invest in properties for conservation across New South Wales. I was formerly a director of one of Australia's most respected environmental consultancies, Ecological Australia. That's a position I retired from in January 2017. I want to be clear that I have no ongoing association with Ecological Australia and am not in any way representing that great company. I'm representing myself, my thoughts and my evidence are my own. In my opinion, biobanking was a great opportunity to address the death by 1,000 cuts afforded by the 7 and species impact statement processes. The introduction of a quantitative, repeatable assessment methodology backed by long-term funded conservation outcomes was a scheme that I had great belief in as being able to address the loss of biodiversity. In Western Sydney, with the publicly announced Growth Centres Conservation Fund of $397 million in 2007, followed by airport and associated infrastructure announcements from 2012 onwards, and Commonwealth immigration policies underwriting ongoing urban development, it was clear that demand for biobanking credits was going to be robust, particularly once the scheme became compulsory for a broader class of developments under the Biodiversity Conservation Act. The ethical investment opportunity in serving critically endangered ecological communities led to my investment in 2 properties in 2013 and 2015, and later the formation of Meridolum in 2017. The Caudle Heights property was purchased by Meridolum in January 2017 after it had been advertised on realestate.com since the 18th of September 2016 and had been passed in at auction without a bid on the 19th of November. After purchasing the property, Meridolum placed an expression of interest on the public biobanking expression of interest register on the 21st of March 2017. Meridolum later sold credits to state and Commonwealth agencies via public expression of interest processes. My employment at the time was fully disclosed to potential purchasers prior to EOIs being submitted. Meridolum is very proud of implementing best practice conservation and restoration ecology techniques on this property and the outstanding conservation results that have been achieved. Meridolum plans to be a long-term owner of this property and is committed to achieving the highest level of conservation outcomes. The run-up in the price of credits in Western Sydney, peaking at $35,000 in 2018, no doubt raised concern within the Office of Environment and Heritage about the long-term sustainability of the biobanking scheme, hereon referred to as the old scheme. Substantial changes were made in the new scheme, including an approximately 70% reduction in credits allocated to stewardship sites, and the equivalence conversion effectively cancelling a similar proportion of existing biobank credits. The credit price was capped by the biodiversity offsets payment calculator at approximately old price, reducing the cost of offsetting by approximately 70%. Red flags were replaced with the less onerous, serious and irreversible impacts test, and there were easier avenues for avoiding like-for-like offsets. The changes had the effect of making it substantially cheaper and easier to destroy biodiversity, discouraged registration of stewardship agreements, pushed up the price of credits in the short term, and predictably led to market failure. The Biodiversity Conservation Trust 2020 annual report identifies that only 4 stewardship agreements were signed in that year, and whilst 18 offset obligations had been met, the BCT had accepted the liability of a further 231 offset obligations that had not been met. Other changes to the scheme, including the replacement of red flags with the more subjective, serious and irreversible impacts test, and easier avenues for non-like-for-like offsets have undermined the integrity of a scheme that is meant to result in no net loss. The BCT has recognised these challenges and had commenced a thorough review of this scheme prior to this upper house inquiry commencing. I refer the members of the committee to my submission that identifies a number of technical issues and provides suggestions on how to improve the biobanking scheme. Thank you.
Thank you, Mr House. That was quite an extensive opening statement. I was wondering if you would be able to be okay in tabling that for Hansard and for the committee?
Yes, certainly.
So you would, if you're able to, I don't know if you could email it at the moment, but afterwards that would be great. Thank you.
Yes, will do.
I'll just kick off with a few questions, and then members, either remotely or in the room here, will have questions for you from the different parties. So, Mr House, what involvement did you have in the development of the state's biodiversity offset scheme?
My involvement with the scheme was limited to participating in some forums that were run by the Office of Environment and Heritage for environmental consultants. From memory, that was 2 forums. There was a lot of consultants at those meetings. That was the limit of my involvement.
Okay, so I just wanted to move to the Hardwick properties, and the Hardwick property. There's a article in The Guardian from the 28th of April, which says that you excluded yourself from negotiations of offset sales from the Meridolum and Hardwick properties due to conflicts arising as a result of your interests in 3 biobank sites. So I'm just wondering, at what point did you exclude yourself?
The exclusion commenced. I'll have to check my dates. You can bear with me one moment. I should be able to give you a reasonably accurate time.
That's okay. And if you could get that would be good. Are you looking through things now, or?
Yeah, I'm sorry. I won't be able to give you that exact date, but I can certainly come back to you with that one on notice, Madam Chair.
Thank you. That would be good. So you were at Ecological. At what point again did you cease at Ecological? Remind me when that was.
The Ecological was. I stepped down as a director of Ecological in I think it was either January or February 2017, and I completely ceased employment with the company about a year later. Early 2018 would be my best estimate.
Okay, so when I'm looking at the Western Sydney Infrastructure Plan, the biodiversity offset requirements from June 2016, and this was the you're aware of this report that Ecological did, Mr. House? This is the Western. I think this is the Western Sydney Infrastructure Plan, the biodiversity offset requirements prepared for RMS.
The 2 reports I'm aware of were the 2015 report that The Guardian referred to and the 2016 report that The Guardian referred to. So if it's one of those,
yes,
I'm aware of it because The Guardian sent them to me, but I'm not aware of any other reports.
Yeah, that's the one. This is the 2016 one. It was just released by the RMS, I understand, after The Guardian did make inquiries about it. So this was in 2016. You were at Ecological at that time, and within this RMS document, it does list properties that you had an interest in, it does list Hampden, Vale, as well as Hardwick as potential biodiversity offset sites. So was that usual for Ecological to recommend biodiversity offset sites that were held by one of their directors? Was that a usual practice of Ecological?
I think the usual practice of Ecological was to actually look at the properties that were located on the public expressions of interest register at the time and to recommend all of those properties to potential purposes that they were advising. And those two properties were there. The Hardwick property was listed on the 29th of July 2014. Hampton Vale was listed on the 20th of October 2016. So I would assume that that's where that information came from.
So there were no safeguards in place, or were there? I suppose the question is around safeguards. Were there safeguards in place at the time to prevent a conflict of interest between your role as Director of Ecological and what later became Purchasing of Land and Director of Meridolum? What was in place?
Yeah, absolutely. There were extensive safeguards in place. So when I purchased these properties, my interest in those properties was disclosed to the board of Ecological. We had independent directors and an independent chair on the board. Ecological set up, I guess, Chinese walls internally. I was not permitted to speak to anybody in Ecological about my properties except for a nominated officer who acted as an intermediary and reported directly to the CEO at the time.
So so you as director of the property, director of one of the directors, director of Ecological, what were the kind of Chinese walls in terms of being able to access reports? When you say Chinese walls, what did that look like in practice?
Well, Chinese walls, basically you're not allowed to talk to anybody about them, so you can't discuss them. I was located geographically a different office to where this work was being undertaken. I was based in the Wollongong office. These projects were run out of the Sydney office, so physically it's obviously quite difficult and quite well separated. Look, really, there's not much more to that other than everybody being made aware that my interest in these properties and not talking to people about them.
And was there anything in terms of access to files? And I do know, for example, some companies, if there's conflict of interest, will have certain accessing files not being able to occur, so they would be kept in a different filing system, if you like, in terms of those electronic files. Did that happen?
Yeah. I cannot be sure of that. I know when Ecological first started working for RMS, and it wasn't on either of these projects that you're referring to, that as part of that obligation, we had to set up password-restricted access to RMS projects. I would assume that this project was also password-restricted, but I'm not the IT officer. I couldn't confirm that that's the case.
Okay, I'll come back. I'll go to questions from the opposition. Ms Penny Sharp.
Thank you. Before I just do, I probably just should make a declaration. I did not know that he would be here. Mr House's lawyer, Mr Lewis, is someone that I know through him being a Labor councillor on Waverley Council, so I just sort of be that up front. Hello, Stephen. I did not know you were going to be here today. So thanks. I just wanted to make that declaration just so everyone knows. Thanks.
I just want to add that I would make the same declaration.
Mm-hmm.
I don't know him.
Yeah, I don't know whether anybody else has any declarations to make. But
no, but I just think these things are. I think these things are important. Thank you. I just wanted to actually just move away from the role in terms of your actual the issues raised by Ms Fairman, and I did want to ask. The question, I mean, the situation that you have found yourself in, Mr House, I think it lends itself, well, you actually make some quite good suggestions in relation, in your submission about the way forward for this scheme. I mean, do you have a view about the difficulties that we have where we have people doing assessments people then being brokers in terms of finding land to find those offsets. I mean, I'm interested in your view about how that can be improved given the difficulties that have been expressed.
Yeah, look, I'm very big on disclosure. I believe that, I guess to wind back a step, I've seen some of the recent policies that the BCT have issued around their staff and excluding staff from participating in the scheme. I think that environmental professionals are the most passionate, some of the most experienced people in this sort of area, and they're exactly the sort of people that you want in this scheme. If you're committed to getting conservation outcomes, experienced restoration ecologists should be encouraged to be in this scheme. Now,
how do we manage then those different conflicts where you've got people consulting for a project, knowing, you know, whether they know the details or not, they know that this is going to be an issue, and they're able to go and look for land, and then, you know, I mean, how there needs? Do you think there needs to be? I mean, it does seem extraordinary to me that people can consult, then also be the brokers, and then also have land that they own, be able to be purchased under this scheme with very little checks or balances.
The first thing I would recommend that there needs to be a public disclosure register. I think if you look at my circumstances, and I'm sure you're all aware of some of the reporting, I made all the disclosures to all the agencies every step of the way, but you know, there's no register of that information. I think if there can be a register of that information that's, you know, publicly accessible, then probably ecologists, restoration ecologists, environmental practitioners getting involved with it. I know there's restrictions on accredited, the ecologists accredited under the scheme. I'm sorry, I don't know the exact title. They seem to be doing their job from what I understand. So yeah, I think that you know, if there's a better mechanism for disclosure, you can more appropriately deal with these sort of things.
And I mean, look, you know, obviously we need people to be able to do these different jobs. Is it the case that there needs to be more separation, where people shouldn't be working on projects that they then go on to be brokers for? Like, I mean,
well, it depends on what your client wants, really. So if you've got a developer that you're working for, who you run the, you know, you do all the analysis, you work out the number of credits they want, and then they turn around and say to you, look, go and find property, then that would seem reasonable to me.
Yeah, okay. I just wanted to go to your submission. You make some pretty strong statements in relation to, I suppose, the old scheme versus the new scheme, where you basically say the new scheme encourages clearing, discourages stewardship agreements, and will need taxpayers to partially fund that. Can you just unpack that for the committee, please?
Okay, so prior, the old scheme, the biobanking scheme, not the stewardship scheme, so as a rule of thumb, there was between 11 to 14 credits issued per hectare that was being protected under a biobanking agreement. Under the new scheme, that was reduced to 3 to 5 credits per hectare. Now, at the same time, the biodiversity offsets payment calculator was brought in, and it capped the price at a price that was similar to the old scheme. So you had a massive reduction in the number of credits being allocated to stewardship sites. Now, the price was...
So the price was essentially the same, but it was just that there was fewer credits given under that scheme. Yep, thanks. Yep.
Devalued.
You still had the same or even higher Part A contributions. You still had the same land costs. You were just getting a lot lower return for your biobank site. Now, initially that price was set below the cost of producing a credit. And not surprisingly, stewardship agreements died quite quickly and very few were registered. That has been progressively increased over time. I understand in 2020 that was increased from 3 to 5 credits per hectare to an average of 5 to 8 credits per hectare, and that the price has been allowed to increase as well. I think it was only 2 weeks ago that the first Cumberland Plain woodland transaction under the new scheme occurred. So maybe there's some green shoots there and some things are coming back into balance. But I guess my rationale for saying that it's encouraging clearing is by setting the price of clearing so low, it makes more financial sense to clear the vegetation than to go through the avoid offset or the avoid mitigate offset hierarchy.
That's right. Can you also, I just wanted to get you to comment as well on the no net loss test. I think your submission essentially says that it's not being met. Do you want to talk to us about that?
Well, I think if no net loss, so the whole premise of no net loss is that the vegetation that's been removed is being offset by other vegetation or other habitat that's been protected in perpetuity and managed back to a high state, and that protection and that increase in quality offsets the loss in geographic area of other habitat. Now, if you've got a situation where the like-for-like rules have been varied, where you've got developers paying cash into a fund, and that fund is not actually able to actually meet those offset obligations, then you're losing vegetation at the same time as you're not actually achieving any offsets or very little offsets. So you can't possibly meet no net loss under that scenario.
My final question, I don't know whether I'm sure others have got questions, but I just got one more, which was actually about your proposal to deal with credit offtake contracts, which is, I suppose, trying to deal with that kind of, give certainty and transparency, but I suppose greater certainty ultimately for people entering into the stewardship agreements. Can you just talk us through that, please?
Yeah, I've seen that there's been quite a few people suggesting in submissions to this inquiry that the BCT or another government body should be going out and purchasing land and setting up stewardship sites on their own. Now, there's a massive financial cost associated with that, and obviously there'll be a lot of additional staff resources required to facilitate that process. I think a much better way would be for the BCT to be entering into contracts or even running an expression of interest process with landholders. Landholders saying this is the return we would like per hectare, and the BCT entering into a contract with them to buy those credits over a set period of time. And that might be a 3-year period, it might be a 5-year period, but it would underwrite, I guess, two of the biggest issues with entering into a stewardship agreement. And that's the risk, firstly, that you're going to enter into one of these agreements and you're not going to be able to sell your credits. Now, the second risk with stewardship agreements, and these are very significant risks, is the moment you sign that agreement, you are liable for the Part A total fund deposit contribution, and you're also liable for any tax that's due or that's payable at the time that you create the credits. It's not based on when you sell those credits. It's at the time those credits are created. So you have to value those credits at what they would be in the current market and pay tax on that in that tax year, regardless of whether you've sold a credit or not. So if you can set up a system where the landowner knows that they're going to have sufficient funds coming in to be able to meet both the Part A and the tax obligations, then you're going to get a lot more participation in this scheme. And if you get more participation, you get more supply, you've got a greater chance of meeting your like-for-like offsets, and you've got a greater chance of this scheme working.
That's it from me. Thank you.
Okay, we'll go to Mr. Justin Field, who I understand has questions.
Thank you, Chair, and thank you for your attendance today, Mr. House. Your submission, and obviously we've all seen the Guardian reports and the reports of substantial profits that were made on those properties, but I want to go to your submission and follow on from where Ms. Sharp was. You indicate you're opposed to the idea that's been put forward by some people of the BCT purchasing and to establish its own stewardship sites. But given, in some instances, the substantial profits that accrue over quite a short period of time to some landholders or people who purchase land and entered into the market, wouldn't it have been more in the interest of state and biodiversity outcomes for the VCT to have purchased that land and to be able to have sold those credits, particularly where they're government agencies that are looking to buy them?
Senator, can I just confirm that you're talking historically? We're not talking about forward. It's actually the past transactions that you're interested in.
Well, no. I guess I'm using the experience of some past transactions as an indicator that possibly it makes sense for the VCT to purchase those sites. And I'm bringing that up because you specifically reject that notion. Because if some landholders, and we've had other evidence today to suggest this has been a terrible investment for some landholders, but for others, some would describe them as windfall gains. So I'm wondering why you're resistant to the idea of the VCT effectively making those purchases themselves.
I'm not necessarily resistant to it. I just think it will be a very expensive way of doing it. I think it would be a much more capital efficient way for the government to enter into contracts with existing landholders and to then then they'll be in a better position to match their pricing into the BOPC because they'll know what credits are coming in and what price they are paying. If the BCT were to step into the market now and buy real estate, I would expect that a seller of that land would at the very least be factoring in lost opportunity costs, particularly in something like Western Sydney where they'd be foregoing any future development. They would look at what a developer would be prepared to pay for that land currently, which would be substantially more than what they would get for biobanking their back bush block or something like that. I just think it would be a substantial capital investment by government that will be required to make a significant difference to the number of credits available, and that money will be better spent by facilitating existing landholders to enter into these agreements.
So you're drawing a distinction then between going forward, but if we just look back a little bit, in instances of those two sites that were referred to in the Guardian article purchased by Ridicule, in that instance, the VCT and the government more broadly, having paid for the credits for public infrastructure, it possibly would have been in their purchase those sites over, given the price that Ridicule was able to purchase them for, would have made much more sense for the VCT to identify the opportunity of those sites, wouldn't it? And of being able to then take that money that would have been paid by the agency and put that into future purchases or better biodiversity outcomes through the VCT's other operations.
Yeah, I guess at the time the VCT didn't exist.
Sure.
If you looked at OEH, their focus was on, I guess, state significant level properties, not like 100 hectares in Western Sydney. They wouldn't touch that with a 10-foot pole because it's a management nightmare for them. RMS, look, they could have gone and bought their own land, and that was certainly an option that they had, but I think we can see with things like the M7 and the offsets for the M7 that maybe they're not the best placed organisation for doing that sort of thing. So yeah, I guess historically they're probably some of the reasons why it didn't happen. I guess if to get more detail on that, you're probably better off asking some of the government agencies directly on why they chose not to.
Yeah. No, and I certainly will. Do you think the sort of windfall gains that some purchasers have enjoyed historically under the old scheme are possible now?
Currently, no. No, look, I'm the first person to admit that we've made some profits. They were substantially above what I was expecting. It was a function of, I guess, the supply squeeze in the market and the changes to the scheme at the time that reduce the amount of credits coming through and push the price up. I think with the changes that have been made that there's no real value in doing this. I had a very quick look at some recent transactions, or the recent transaction on the 25th of November, and the pricing in the calculator. You're probably at a point now where you're getting a rural land value plus your Part A covered, but there's certainly no profit in it for brokers or land investors or the like right now.
I might come back actually, Chair. I might have one other question, but I'll hand over to others. Thank you, Mr. House.
Thank you.
Okay, I can jump in. Catherine, if you've got questions?
Oh, okay.
Yeah, go for it.
I guess my question is, what would happen if the government vacated this space and developers went back to having to organise their own offsets?
That's a good question. I think right at this point in time, if that were to happen, the price of credits would skyrocket, and you would wind up in a position where developers could not find credits because the demand would quickly outstrip supply. I think that one of the other big problems in the scheme is it takes a year or more to register a stewardship agreement, whereas you're getting approvals for clearing within a month. So you've got this real disconnect timing-wise in terms of credit demand and credit supply. I'd expect that you'd have a massive increase in credit prices, and developers would simply not be able to find the supply to offset developments, and things would probably grind to a halt pretty quickly until the market had time to respond to the demand.
Can you see potential for more of a mixed system whereby this was, as I understood it when this scheme came into place, it was meant to be a last resort for developers who kind of couldn't access offsets anymore, but it seems to have turned into the main game. So is there merit in trying to get it back to the original concept, potentially over time, so that you wouldn't... I think what the evidence we're hearing is that just suddenly announcing massive changes to the scheme that take place overnight has had some perverse outcomes as well, but some kind of a plan to get us to a better place?
Yeah, look, from a conservation perspective, I think the two changes I would focus on straight up would be the like-for-like provisions. If you're not having like-for-like, you're basically winding up with a transfer high real estate markets like Western Sydney and the Hunter to regional real estate markets or regional ecosystems, because the prices, the way they're set at the moment, it's just not going to encourage people to protect their land in Western Sydney. And if that money is getting paid into the VCT, then either the taxpayer is going to have to top that up to get like-for-like credits, or it's going to have to go to other conservation priorities across the state. I think that's the first thing you need to address, is that like-for-like, to sort of close that opportunity. That would have a flow-on effect for prices for the credits, which will at some point result in a supply response. The other thing we used to have was red flags. So red flags were no-go areas that they couldn't be cleared. They could only be cleared. Actually, sorry, I'll wind back. There was 3 sub-schemes within biobanking. You had biodiversity certification. You had the biodiversity assessment methodology, which was the major projects and infrastructure methodology, and then you had the BAM, which was your more standard Part 4 assessments under the old schemes, so property developers and the like. So red flags could only be varied in the biodiversity certification process, or in the state significant infrastructure process. So you had, I guess, state government had the opportunity to vary those things, whereas local councils through the Part 4 assessments couldn't. Now, once those red flags were removed and were replaced with the serious and irreversible impacts test, there was scope for these more important things to be varied or approved or cleared at multiple levels. I think the red flags were definitely a better system and had a lot more rigour to them. I would.
Sorry, that's better for the environment?
That's better for the environment.
I just wanted to be clear, yes.
Yeah.
And just one other question. You talk about, in your submission, it says, with regards to changes made in the new scheme, it's noted that the avoid, mitigate, offset hierarchy has statutory teeth, as shown in recent land and environment court cases, and then listed 3 cases. Could you just explain that a little bit more? Because I'm not clear on what you mean about the statutory teeth, and I'm not familiar with those cases.
So those 3 court cases, all of those cases found in favour of the councils, not the developers, and all of those cases made reference to the avoid, offset, mitigate hierarchy, and that it hadn't been applied in those cases. And in the case of IRM Property Group versus Blackdown Council, they also, I'm pretty sure it was that one, they also referenced the serious and irreversible impacts test as not being met as well. So there are clauses within the legislation that do have statutory teeth, if you like. It may just be a case of it being a new system and, I guess maybe local government not being fully aware of how to use these new statutory instruments.
But there's not a consistency in how this is operating around the state? That seems to be the implication?
I couldn't say for sure. I left the industry a few years ago, so how it's working right now, I'm sort of relying on what I've heard through my contacts. So I couldn't say what's happening across the state at this point in time. I'm sorry.
Is it appropriate for public reserves to be used for offsets? I just thought they would already be protected.
If they're done in the right way, then arguably they could be, but it does depend on how much additional improvement that you're going to get in your biodiversity outcomes within those reserves. There is a risk in that they also do distort the market. I know under the old biobanking scheme that council reserves were issued a much lower number of credits per hectare. And at the same time, you had Commonwealth approvals referencing offsets in hectares, not in credits. So it was actually cheaper to buy state government credits at a council reserve at a much inflated price than because you were protecting so many more hectares and meeting your Commonwealth obligations.
Thank you.
Thank you. Mr. House, I just wanted to go back to the Guardian article this one's from the 28th of April, and it goes through some detail as to the history of Ecological's involvement, if you like, in firstly developing the government contracted Ecological to do the 2007 conservation plan for the growth centres, for Sydney's growth centres. You're aware of what I'm talking about there?
Yes, I'm aware of that.
So what involvement did you have with that? That's back in 2007, but that clearly would have been quite a big project for Ecological, I assume, because that's a huge area, those growth centres.
Yeah. It was a very significant project. It was largely a desktop project. I wasn't closely involved with that project. I may have reviewed draft reports, but I can't be sure of that given the passage of time since then. But I wasn't project managing it. I wasn't involved at any sort of significant level in that one.
I mean, you would have had, being a director of the company, you would have had had some kind of an idea of those growth centres and the infrastructure required, bulldozing of habitat for new suburbs. It says here 181,000 new houses. You would have had a fairly good knowledge of the clearing of all of the Cumberland Plain woodland, the clearing and the offsets that would be required from your work at Ecological.
Yeah, it's certainly a project that became very familiar with, but I wasn't involved in the actual preparation of the conservation plan itself.
But in those years from 2007 through to 2010 and 2013 and 14 and 15, there were the company that you were director of did a hell of a lot of ecological assessments for major projects in Western Sydney that was going to clear Cumberland Plain woodland. That's correct.
Yeah, absolutely. And we undertook, I would say, the vast majority of the precinct planning studies within the growth centres, and I either was the project manager or the project director on most, if not all of those. So I was very familiar with what was going on in the growth centres.
So then you're very familiar with what was going on in the growth centres, and then around the time, when was it that you started purchasing land, the companies that you're director of that purchased what is known as Hardwick and Hampdendale, for example?
Yeah, Hardwick was exchanged on the 13th of December 2013. Hampton Vale was the 28th of October 2015, and the Quarter Heights property was the 27th of January 2017.
And so at this stage you're still director of Ecological, that is doing assessments, ecological assessments for the government. Was some of the how big are those properties actually, Hardwick and Hampton Vale?
Hardwick's 600 acres. Hampton Vale is, 240 hectares. Hampton Vale is 105 hectares.
So just coming back to you kind of assuring us that you were very clear that there was no conflict when you became director of Meridian, but were still at Ecological. So, and you said that there was kind of Chinese walls and everything. Is that correct?
That's correct.
So that remind me as well the time the time you became director of Meridian.
It was January 2017.
So I have done, and I'm sure you're aware, Mr. House, the New South Wales Upper House did a call for papers to just have a look at what was going on between the department and Ecological, just to see what was going on behind the scenes. You did say to the Guardian that you weren't involved in negotiations, but I have emails that do show that you were inquiring as to what offsets the department may be interested in from the Hardwick property. So from the emails I have before me from December 2017, the 6th of November 2017, you were actively still inquiring right up to the 13th of August 2018. You were inquiring to the department about purchasing credits from Hardwick and Hampden Vale. So what does excluding yourself from negotiations look like?
Okay, so firstly, yes, I totally was making inquiries to the government. So the excluding myself from those negotiations was actually related to concerns that we identified that my involvement across 3 properties could fall foul of the cartel provisions of the Corporations Act. And that was when we first met with Western Sydney Airport, which I don't have the date, but I would be thinking it was late 2017, possibly late 18. I just remember it was late in the year. It was in that sort of area. So my non-involvement was basically to make sure that the three properties were competing with one another and weren't colluding with one another, and that we were meeting our obligations as directors under the Corporations Act.
So it was more a concern about collusion between the three properties as opposed to any concern that you as director may have had access to all of this information as a director of ecological, if you understand. There was no concern there that you were then, as a director, still at ecological, contacting the department, selling, trying to put in front of them the offsets from Hardwick and Hampden Vale that you then proceeded to make tens of millions of dollars from. That's the...
Can you be more specific about this information that, all of this information that I had access to, please?
Sorry, when you say the information you had access to?
With respect, Senator, you just said I had access to all of this information. Could you be specific about what that information is, please?
So, I was just talking to you about from, all through from 2015, 2016, 2017 as Director of Ecological, knowing that there were, a hell of a lot of major projects being assessed that would need offsets. You were purchasing property at the same time, and you have said publicly that you put in place measures to ensure that you're excluded from negotiations. But I have emails that still have you as Director of Ecological and actively pushing your offsets to the department.
Yeah, with respect, Senator, I've just explained what those measures were about, and that they were about the cartel provisions. Now, with regards to communications with government authorities about selling these credits, my employment with Ecological and my ownership of those properties was fully disclosed to the government authorities prior to that happening. In fact, the government authorities, certainly RMS and Western Sydney Airport, in the very first meetings I had with them, I disclosed that information, and both of their responses was, we already knew that. So this wasn't some big secret. This was information that was well known. The procedures that were in place, and they were working.
Did it give you an unfair advantage, do you think, over other property owners in the area that may have been wanting to sell their credits and biobank their land? Do you think you had an unfair advantage then?
No, not at all. All of these properties were placed on public credits, or public distribution of interest register. I would assume that anybody who wanted to enter into an agreement or had entered into an agreement would have placed their properties on the register as well. Certainly with these bigger infrastructure projects, the report that you referred to earlier in 2016 had a list of the properties that were on that register. The GHG reports to the airport also had a list of the properties. I was in the same boat as everybody else with, the properties being out there and being publicly known.
Ms Cusack's got a question. I'll just throw to you.
Yeah, I guess it's maybe a slight difference on the ones that Ms Farman has been asking, but do you think that your work for the government as a consultant gave you information that was informed which properties you purchased and which investments you made? Was a lot of the information that you used in making those investment decisions derived from your work as a government consultant?
So the projects that I was working on at the time with the growth centres were the precinct planning, the rezoning stages of the various precincts within the growth centre. Now, the way that the growth centre's biodiversity certification order works is that any offsets identified during that precinct planning process had to be sourced from within the growth centres. All of my properties are located outside of the growth centres. It's not possible for any of the projects that I was working on to actually buy my credits. So no, the projects that I was working on, I didn't have any additional information. They literally could not buy credits for my properties. It would have been inconsistent with the Act, or with the Biodiversity Certification Order.
What motivated you to purchase those particular properties? I mean, did you see an opportunity there? Because they were investments, weren't they? Yeah.
The first property, I actually purchased that as part of a consortium with a client, a property developer who needed to find an offset. They engaged me to talk to landholders to try and get their neighbours to enter into offset agreements, and I actually couldn't convince anyone to do it. They just saw it as something that was too risky. So that developer asked me to find a property of about 30 hectares in size to buy a bank and to do it himself. Now, I was just searching realestate.com and the Hardwick property came up. It was 240 hectares in size. I went back to the developer and said, I think this one would do for you, but it was too big for him. And I asked if I could come in as a partner in it. So that's how that started. And in all honesty, in doing that one, I probably realised just how little I knew about biobanking. I was never an accredited assessor. My only involvement with the actual biobanking scheme was during those consultants forum that I mentioned at the start of this session. I've got a passion for restoration ecology. I set up the bush regeneration team and the land custodianship team when I was at Ecological. It was something that it was my philosophy. I just saw it as a really good opportunity. Certainly at that time, the credit price was, not that financially attractive, but yeah, it did march up from there and became quite a good financial investment as well.
I've just got another line of questioning then around the 2016, this is the other one that was mentioned in the Guardian's article, the 2016 environmental impact statement that for the Western Sydney Airport that was prepared by GHD, the consulting firm. So that named Hardwick and Hampden Vale as potential biobanks from which the federal government might purchase offset credits. So it also says here that neither had been registered, had been a registered biobank at the time. What was the process? What was the process there? How did, like they weren't registered biobanks, what was your process with GHD?
Yeah, so I've gone through that report as well, and I've also gone through the Guardian's comment, to quote from the Guardian, but neither had been a registered biobank at this time. In fact, GHD wrote that it was alerted to Hardwick through personal communication with another staff member at Ecological Australia. That statement is factually untrue. The GHD does not write anywhere in that report that they were alerted to the property by Ecological Australia. On page 33 of that report, they actually state the methodology that they used to identify these properties. Their first step was to look at the Public Biodiversity Credits Register. The second step was the Biobanking Expression of Interest Register. The third step, the Biobanking Assessment Reports, and the fourth step was consultation with private landholder and government agencies. Now that was in, what was that, 2016? So I think I mentioned to you before that Hardwick was placed on the Biobanking Expressions of Interest Register on the 29th of July 2014. Hampden Vale was on the 20th of October 2016. The first contact we had with GHD regarding the airport was from their senior ecologist that emailed us on the 15th of July 2015. The email starts with, "Dear Stephen, I got your details from the Biobanking EOI register. I'm preparing an offset package for a developer client who needs the following credits listed on your entry on the EOI register. It's really obvious that they got our details from the EOI register, I think.
So sorry, continue.
No, I'm done, thank you.
Okay, so Hardwick and Hampden Vale, so what did you purchase Hardwick for, and both of those properties, what did you purchase them both for, and how much have you received in biobanking credits for those two properties?
Well, I've already explained the Hardwick property and the relationship or how that acquisition came about. The Hampton Vale property I bought as an investment. I intended to biobank some of it. I didn't actually intend to biobank as much as I eventually did. I'm sorry, but I don't have details on the actual credit sales of the quantity or the value of the credits that I sold on either of those properties, but I can certainly get those to you on notice if you would like them.
Yeah, if you don't, so you don't have okay, that's fine. I thought that would be something that you would have quite to hand, but that's okay. We'll go to Mr. Justin Field for questions.
Thank you, Chair. Thank you, Mr. House. I want to go back to the line of questioning I was on before, and I'd asked you if you thought that the sort of windfall profits that you acknowledge you were surprised by, and I guess I'm referring here to the Razorback sites really, you didn't think that was possible under the scheme these days. Can you just, I might have cut you off in your answer there, but my understanding of what you said was basically now the prices aren't there, but also, it seems to me people have more of awareness of the value of these properties as well. Would that be correct?
Yeah, the first indication of that one is I saw properties advertised by real estate agents marketing them as biobank sites. So, I think once the real estate agents know about it, it changes things quite a bit.
But you admit that someone sitting on land, even if it had those sorts of biodiversity values and potentially could become part of the offset credit market, an average landholder wouldn't have the ability to do the work to bring it to market in that way. It would require quite a lot of money to be spent on land, correct?
To be spent on land, or
to be spent on doing the accredited assessment on the land.
Yeah. So it would be quite a bit of money. I'm not an accredited assessor. I had to pay consultants to do the work for me. I also had to pay for a second round of consultants to independently audit the reports as well. So I was in the same boat as any other landholder in that regard.
For example, the Razorback sites, Merritt would have made a judgment, or I guess the first question is, did you see that those sites were on the market and you were aware of what might be in the pipeline for government in terms of potentially wanting to purchase sites and you saw an opportunity there, or were you out talking to landholders about that opportunity and sort of pitching purchases?
I spoke to one landholder who was my neighbour at Hardwick, who was not interested in biobanking due to the risks and concerns about, I guess, the future loss of value in the property. The remaining properties, I just found them advertised on realestate.com.
So, I mean, we're talking about 2018 for the Razorback sites. I think, if the Guardian story is correct, I mean, at that stage there would have been quite a bit of awareness of biodiversity offsets and biobanking scheme, of large government projects out there. Were those landholders aware of the likely value of those properties once the accredited assessment was done?
I know that the Caudle Heights owners were made aware of them. Their property was subdivided. It was an inheritance. One of the siblings retained 100 hectares, and the other two siblings sold their 200 hectares to us. As neighbours, we've got to know the other sibling quite well. He's been quite telling his sisters to biobank this property and that it was worth doing, but they chose not to. Our neighbour to the south at Cawdor Heights already had a biobanking established years before we purchased the property. My neighbour at Hardwick was in the process of establishing a biobank before we purchased that property. Their biobank's been established as well. So the biobanking was quite well known in the area, and the Office of Environment and Heritage had been actively going around and marketing the biobanking scheme to landholders for several years by the time these properties were purchased.
Sorry, but I guess the property I'm primarily looking at is that large site of 519 Old Razorback Road. What's the name? That's not one of the properties you're referring to here, is it?
Sorry, that we call that Cawdor Heights. That's
Cawdor Heights.
Meridian property, yeah.
Yeah, okay. But when you purchased that, there wasn't a biobanking agreement on the site at that stage. It hadn't gone through its credit assessment process at that point, right?
That's
yeah, okay. So it was quite a short period of time between you purchasing the site, you banking it effectively in the offset scheme. It was quite a short period of time before those credits were then on-sold to the RMS. So is it just a case there of you were just in the right place at the right time, or you had an awareness RMS was going to be in the market for something very close to this very soon?
Yeah, it was about an 18-month process. I had no awareness about when the RMS would be in the market. I was fairly certain at some point they would be, unless they sought to do their own offsets or do a deal with councils or do a deal with Western Sydney Parklands. My bigger focus was always on the longer-term growth centres conservation fund and the Western Sydney Airport. I think their announcement was in October 2015, November 2015, something like that, and they had a $140 million estimate of what their offsets were going to be. So it looked like, there was going to be a bit of a substantial increase in demand when the airport came on board.
Right, but you say it's an 18-month process, but I think, and the Guardian story notes that from the time it was, they call it banked, in the offset scheme, but I guess that's the time it was registered. It was like a month later that RMS purchased those offset credits from Meridian. Is that right?
Yeah.
That's a really small window of time.
Yeah. So the RMS went through an expression of interest process. Once they identified the properties that they wanted, they entered into options agreements to purchase the credits once, or in the case of the Cawdor or Meridian property, to purchase the credits once the biobank had been registered. As a landholder, you would be absolutely mad to enter into a biobank agreement if you didn't have some sort of guarantee that credits were going to be sold. And that's because of the issues I raised earlier with the TFD becoming due as soon as you enter into the agreement, and also the taxation implications for entering into the agreement. So it was common sense for us to enter into an options agreement with the RMS so that they could, we had some certainty that we'd be able to sell credits, and they had some certainty they'd be able to buy the necessary credits.
Mr. House, can you just explain TFD, that acronym, for Hansard?
It's total fund deposit.
Thank you.
Also, it's Part A. So it's basically the management funds for the property.
Thank you.
Do you still own that site?
Yes, and we will own that for the long term. We're very, very committed to the conservation works on that property. I'm a passionate restoration ecologist. I love being out there and I love what we're achieving.
Okay. Sorry, Chair, I can see there's limited time. If anyone else had questions, I'm happy.
Sure. Mr. Pearson has a question or two.
Yep, thank you very much. I just apologise in advance because my head is finding it very difficult to get around this whole scheme and understand it clearly. So perhaps if you could just clarify something for me. I have heard, and some of the evidence has been given to us, and I think you may have said the same thing, that sometimes clearing a bio-offset land makes it more valuable in terms of a bio-offset than planting trees. Is that true?
It would depend on, I guess, Senator, where that was occurring. Certainly in Western Sydney, a cleared piece of land is a lot more valuable than a vegetated piece of land. Might be a bit different in other places, but yeah, development land, you'd be looking at $2 to $3 million per hectare. Vegetated land in Sydney, you'd be lucky to get, you wouldn't get a tenth of that, that's for sure.
But doesn't that go against the very principle of the purpose of the scheme? Just to replace harm to biodiversity with protecting it?
I'm very sorry, Senator. I think I've misunderstood your question. Could you rephrase that, or just ask?
Well, I mean, my understanding is the reason these are purchased is because there's going to be a development or a project which is going to remove habitat or cause damage to the environment, and the purchasing of the biodiversity offset is to try and replace that. Just like you said, you think the rule should be like for like. I thought that statement came from a concern of the clearing of land is making it more valuable as a biodiversity offset as opposed to planting trees and making it more environmentally healthy.
Yeah, I'm sorry. I thought you were talking about from a financial perspective.
No.
It's much more valuable for biodiversity-wise if you're removing the weeds, if you're planting trees, if you're managing all the other impacts to biodiversity.
Okay, thank you.
Thank you.
I just wanted to ask about the process then for turning now to the Western Sydney Airport, the offsets for Western Sydney Airport. So how much, hang on, I'm just trying to find. So I have here as well that over a 2.5-year period that there was more than $100 million in offsets sold across all of the properties, so the properties that you own or have a interest in, Mr. House, including, I understand, is it $37.5 million for the Western Sydney Airport? Does that sound about right?
Senator, that sounds reasonable. I don't have those numbers with me right now, sorry.
Okay, so
it certainly does not sound unreasonable to me.
And so which of your properties are offsets for, remind me, which are the offsets for the Western Sydney Airport?
All three properties are offsets for Western Sydney Airport.
Okay, so I'm just trying to work out, like, in terms of the offset. So you have, who originally undertook the assessments on, for example, Hardwick? Who undertakes the assessments of that property, the ecological assessment to determine what biodiversity credits are on there? Who did that?
Ecological Australia undertook the initial assessment.
And when did they do that? When was that initial assessment?
2014. It was during 2014. It would have been a 6 to 12 month process to get it.
Did anybody peer review that assessment?
Yes, I did.
Who was that?
We had OEH, and I think there was a consultant, but I'm not sure which one it was. I'd have to go back to the records on that to find out.
And is that that's a formal peer review by OEH, is it? Or is that another assessment entirely, or what does that peer review look like by the OEH?
The peer review included, I know they inspected the site, to, I guess, to review the vegetation mapping work that had been done. They certainly reviewed, I guess, all the calculations and the credits. I don't know if there was a report or anything like that done. I wasn't privy to that information.
So the original assessment, you say, was done by Ecological Australia at the time that you were a director of that company. That was for Hardwick. Did Ecological do the ecological assessments for the other properties that you have an interest in?
So with Hampton Vale, so I own Hampton Vale on my own, so I thought it wasn't appropriate for me to actually use ecological because there was no separation. So with the other properties, they were project managed by other partners in the relationship. So I used GHD for Hampton Vale, and that report was peer reviewed by Parsons Brinkerhoff. And then with with Cawdor Heights, because we had other directors in Meridian who weren't employees of Ecological, they project managed that process. They used Ecological to do the initial assessment, and the audit and peer review was done by GHD for that one.
I mean, that is pretty extraordinary, really. So let's go back to Hardwick, when I understand you and Mark Adams as well, who were directors of Ecological. Is that right? So, and is Mark Adams also director of Meridian?
Mark is a director of Meridian. I'm not sure if he was a director of Ecological.
Sorry, that's what I meant, my confusion. Yes, he's director of Meridian. But so you thought it was not okay because you're the sole director of Hampden Vale to have Ecological assess it. Why do you think it was okay with you as a director of Hardwick that Ecological assessed that? Don't you think that itself is enough of a conflict of interest to get another consultant to assess the property that you were going to stand to benefit millions of, depending on what credits were found by the assessor that did it?
No, I don't. So with the two properties where Ecological Australia was used, we had other directors of Hardwick and Meridian that were project managing and liaising with Ecological Australia, and I had no involvement with Ecological Australia during that process.
So, I mean, you can. Obviously, we'll have a lot of questions for the government tomorrow about how such a situation like this could have arisen. That situation where the company that you were director of, was able to undertake the assessment, which you said was a very extensive assessment. Was that right? Over. Yes. You said it was like 18 months or something, did you? Because it was such a big property.
Well, the approvals process was in that months realm. The actual assessment, I'd only be guessing if I gave you a time frame on that.
But it was an extensive on-ground desktop assessment. Sorry, not desktop, on-ground. So, on-ground's kidding.
It's a substantial amount of on-ground fieldwork undertaken by extremely experienced ecologists with way better field skills than I've ever had. It's a very specific quantitative methodology. It's complicated. It's not easy, and there's a lot of work that goes into it.
I mean, you must have surely worked out that you'd really was on a winning ticket, so to speak, with being a director of a company that undertakes assessments and knowing that if you bought the right land and got the right species, you were going to make tens of millions of dollars. So no doubt you were. I mean, this is what was going on. were you advising your mates and everybody else to get on board too?
Well, frankly, Senator, with all due respect, I find that ridiculous. There was no guarantee at all that I was going to make a cent out of this. There was every prospect that I was going to wind up with a massive liability out of this. I think that's a disgraceful suggestion.
How was it? How would you have? How would you have ended up? What was the likelihood of you ending up with a big liability as opposed to making tens of millions of dollars? I don't understand that. I mean, it's a genuine. It is a genuine, statement to you that you really. It sounded like you had a hell of a lot of knowledge to be able to make a lot of money.
There was every chance that the airport or RMS was going to buy credits from any other provider of credits in Western Sydney. There was also every chance that I was going to get caught up in the change from the old scheme to the new scheme, and my credits were going to get reduced by 70% or more, and I was going to get left with a massive tax liability that I would have had no way to pay.
All right. Well, thank you very much, Mr. House. That actually is the end of our time and end of our questions. So I do appreciate you agreeing to appear before this inquiry, and I believe you have taken some questions on notice which the Secretariat will get in touch with you about, and you'll have 21 days to get those back to us. So thank you very much, and we will now break for afternoon tea, and we'll be back at 4:10. Thank you. Okay, all right, let's commence our next hearing, our next session with our witnesses. I just wanted to check that we have, firstly, Ms. Claire Doherty. You there and can hear me okay?
Yes, I'm here.
Thank you. And Mr. Atkinson.
Yeah, I'm here too.
All right, we'll swear you both in. We'll start with you, Mr. Atkinson. If you could state your name and position title, please, and swear either an oath or an affirmation, which I believe you have those words in front of you.
Yes, I'll just have to. I've had some, as you'd be aware, IT issues like most folks. And I have to tell you, could you go to the other person first, because I can't get my copy of my.
That's okay. I can bring. That's okay. Let's just. Would you like to swear? Do the oath or affirmation? I can read the words out if you repeat after me, if you like.
That would be fantastic. Thank you.
What were you planning to do? The oath or the affirmation?
Affirmation.
Okay, all right. So, firstly, if you just state your name and position title.
Angus Atkinson. I'm a beef farmer from Coonabarabra, New South Wales.
Okay, and if you could repeat after me. I solemnly, sincerely and truly declare and affirm.
I solemnly swear, affirm and declare.
Yes, there. That's pretty close. That the evidence now about to be given.
That the evidence to be given.
By me shall be the truth.
By me shall be the truth.
The whole truth and nothing but the truth.
The whole truth and nothing but the truth.
There we go. Thank you very much. And we'll move to Ms. Doherty. If you could do the same. I assume you have yours in front of you.
Yes. My name is Claire Doherty. I'm a Policy Director from the New South Wales Minerals Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Would you like to make an opening statement, Ms. Doherty? And I assume you do as well, Mr. Atkinson.
That'd be great, thank you.
Okay, if you wanted to kick things off, Ms. Doherty.
Yeah, great. Well, I'd like to acknowledge that today I'm on Gadigal land and pay my respects to the elders past and present. I'd like to thank the committee on behalf of our New South Wales Minerals Council members for this opportunity to contribute to the discussion on the integrity of the biodiversity offset scheme. The New South Wales minerals mining industry has been a long-term supporter of reforms to biodiversity offsetting that increase consistency and base all assessments on a robust and scientific method.
If you just pause for a second, please, Ms. Doherty, and maybe moving yourself slightly closer to the microphone. You're coming across as a bit muffled, and I think you might, if you can move the computer closer to you, or
listening in very up close.
Yeah, no,
is that better?
It is. Thank you. Do you mind starting again?
Yeah, I can start again.
Thank you.
So I just wanted to acknowledge that I'm on Gadigal land today and pay my respects to their elders past and present. And also I'd like to thank the committee on behalf of our members for this opportunity to contribute to the discussion on the integrity of the biodiversity offset scheme. The New South Wales mining industry has been a long-term supporter of reforms to biodiversity offsetting that increase consistency and base all assessments on a robust, scientific and repeatable method. We were early contributors to the development of the biobanking scheme, with some of our members voluntarily applying the biobanking tools on their projects to facilitate a better understanding of the scheme. One of our members created and continues to own and manage one of the state's earliest biobanking sites. We contributed constructively to the reviews of the biobanking scheme and the development of the biodiversity offsets policy for major projects and the framework for biodiversity assessment. We participated in consultation around biodiversity conservation reforms. We supported the development of mechanisms that provide in perpetuity protection for offsets. Overall, the BOSS is much more rigorous than previous schemes. It drives much higher offset requirements for projects and implements a much higher standard of security and management for offsets. The introduction of the BOSS was a large and complex reform. Not surprisingly, a number of issues have come evident since it began operating. 2021 has been a year of considerable scrutiny for the scheme. This inquiry has been influential in the government's review of aspects of the scheme. In addition, issues around the supply of biodiversity credits, the price of credits and the state of the offset credit market have come to a head and are getting government attention. The Biodiversity Conservation Trust is redesigning the developer charge system, and the government is looking to address value in the offset market and supply of credits. Both the BCT and the government are for the first time considering the barriers to entry for private landholders, what this means for the offset market, and how the government will need to adjust its approach to unlock the supply of credits. A number of issues have been raised before the inquiry relating to offsets in the mining sector. I expect the committee will have some questions about those issues. It's important to note that because of the long time frame for mining projects, that although the was commenced in 2017, recently decided projects have proceeded under older offsetting regimes. Additionally, some issues, including delay in finalising security for offsets, have largely been caused by changes to the offsetting regulation and policy regime. And again, centred on approvals under earlier offsetting schemes. It's crucial not to conflate the process for registering an offset against the title of a property with the acquisition and management of that property, which goes on despite delays around security mechanisms. It's also important to recognise that many of these transitional and legacy issues will not arise under the BOS. Under the BOS, offsets now need to be secured in perpetuity and the costs of the management paid up front to the government. Development cannot begin until credits are retired or an equivalent payment is made to the Biodiversity Conservation Fund. It's appropriate that the scheme is being subject to scrutiny and review. We're cautiously optimistic that in 2022 we'll start to see a resolution of some of the issues that have become evident since the operation of the BOS. Thank you.
Thank you very much, Ms Doherty. Mr Atkinson.
Thank you. Good afternoon, committee. As you say, my name's Angus Atkinson and I'm a cattle farmer from Coonabarabran. I'm a member of the New South Wales Farmers Association and I'm the chair of the National Farmers Federation Sustainable Development Committee, and I'm speaking today on behalf of New South Wales Farmers Association. Biodiversity and other natural capital services have been clearly identified by the National Farmers Federation as an important part of agriculture's $100 billion 2030 target, and therefore programs like the New South Wales Biodiversity Offset Program are an essential part of that target, and getting them right will help deliver a more sustainable agricultural sector. Like climate change, farmers have already done a lot of the heavy lifting when it comes to biodiversity. Farmers have been forced to retain vast areas of vegetation for the community good and not received any compensation. Properly set up and managed offsets gives farmers the opportunity to be more drought resilient and provide a valuable source of income during dry periods. Also, compared to buying an entire farm and then locking it up, offsets provide the community with a reliable source of income while maintaining and improving the property's natural capital and benefits to the local community. We believe that conservation should be all about including people, not excluding people. Now, given that my family's been farming our farm and in our area since 1958, sustainability is at the centre of our business. It's really important to remember that the majority of native vegetation in New South Wales is located on private land. For schemes that seek to conserve and improve this biodiversity to be successful, it's vital that private land managers have a seat at the table. Getting the scheme right for landholders will increase their participation and effectiveness of the programs in achieving a no net loss. My family have had significant impact by biodiversity legislation without any compensation. Like many farmers, our property rights have been significantly affected, and this situation must be addressed through schemes like the Offsets Project. Landholders are already providing environmental services, and they should be offered some type of incentive and reward for doing those. The last thing any government should do is punish landholders that have done the right thing. An example for us is the koala legislation at the moment, the regulations. Landholders with koalas should be rewarded, not penalised with greater regulation and loss in property value. I'll briefly outline the main barriers limiting the current effectiveness, what we believe the current effectiveness of the offset schemes, and a number of issues regarding the biodiversity offset scheme. A lack of recognition of existing biodiversity, additionality is a phrase that we hear quite often. Lack of information regarding the market of the biodiversity credits. A lack of independent advice for landholders. Again, concerns regarding a small number of projects that have been funded by or done through the BCT, which are extremely expensive, versus some voluntary projects that are offered very low per hectare rates. The lack of ownership for where the total fund deposit goes once it's been collected. Linkages with other natural capital services like carbon sequestration. We were concerned, and again, I understand it's been reformed to the BCT's calculator, which again has given some people a false expectations of pricing. There's a lack of progress in Division 6, Part 5A of the Local Land Services Act. And a real issue for us is comparing agriculture and development on agricultural land for agriculture to a car park, where there is permanent change. We compare, and agriculture basically gets lumped in as if we're a car park, and we find that to be just something that is unreasonable. My personal experience with offsetting programs. Look, I've got a longer statement here, but I'll try to summate it. But we bought a farm in 2002, and unfortunately that farm for us was caught up in the listing as under an ecological community. So when we bought it at auction, it wasn't. By the time settlement, 6 weeks later, it was, and that was a 820 hectare farm. The whole farm was under that. In 2019, we put an expression of interest into the inland rail to provide biodiversity offsets for the new railway line. After a considerable time, representatives of inland rail advised us the property could be potential for an offsetting site. We repeatedly contacted them, inland rail, but we never heard anything about it. In 2020, we decided to investigate the New South Wales Biodiversity Offset Program. Once again, we repeatedly tried to contact the BCT, and we were just unable to do that. And sadly, we had to rely primarily on the advice we were getting from our consultant. We contacted an environmental and heritage consulting company to discuss the possibility of using one of our farms. The consultant advised us that the area was very suitable. It was 820 hectares. The plant community types that existed were in demand. We paid for a half-day site visit by an accredited BASAR assessor. That confirmed the plant community quotes, and the report that they produced advised us that we would produce approximately 2,000 biodiversity credits worth an average of $3,000. As you can see, that's a reasonable amount of money. We were advised that to do that, we'd have to spend $85,000 to get a BASAR done, and once we'd done that, we'd be in the position to sell those credits. And of the money that we generated, the government would have to retain $2 to $3 million of our total fund deposit. Now, due to the lack of information that was available again with the BCT, the real value of those credits was not right. We relied, and I suspect that our consultant used the BCT to estimate what the developer would have to pay for our particular plant community types. But that assumed that we would be able to sell them, and that's what we haven't been able to identify yet. Despite this, we decided to go ahead and we signed a contract to complete a BASAR costing about $85,000. After the first week of site inspections, things started to go wrong. Our ecologists were warned that some of the plant community types that were meant to be on the farm actually weren't, and that it would take an additional week of survey work costing another $17,000. Reluctantly, we thought, well, we're committed now, and we understood that we were early adopters, so we needed to take a risk. But at the same time, the consultants that we were dealing with had won a contract to supply the inland rail with biodiversity offsets. Now, I asked the ecologist if he knew about our expression of interest in the inland rail project, and I was eventually told that the consultants that we were using, one of their, you might say, sister companies, had looked at our expression of interest and determined that our property was not suitable for that. And at no time did Inland Rail or the consultant advise me in writing what and why our expression of interest was declined. Now, that got me extremely concerned. I was extremely concerned that a big project in my area, Inland Rail, and also the Santos Gas project, which I thought would have been potential buyers of my credits, required none of the plant community types that I would have created. At the same time, the BCT released one of their fixed price offers, and sadly, the plant community types that they wanted were in other IBRA sub-regions, not where my farm is located, and therefore I couldn't participate in that part of doing it. So at that point, I was looking at it thinking, wow, I really wondered whether I'd been caught up in a Nigerian scam where I just needed to keep spending more and more money to try to get my money back, to be honest. I'm not accusing in any way the consultants that I've engaged. They were just using the information that they had available. Now, I've suspended that project. We've probably spent $70,000 so far, and I've been told by the consultants, unless I pay the relatively small amount of money that I owe them for the work they're completed, that they will retain all of the data that they collected. Now, the major lessons for me personally regarding that was that there was simply not enough information regarding the demand for credits that were going to be done for me. There was no readily available service to get independent advice on the biodiversity credits. And also that there was obvious conflict of interest between consultants that are being paid to estimate the value of projects and then also do the assessment of that project. Now, that to me, so that, again, I'm not accusing the guys that I did it with, but I'm just saying they were just telling me that really the better the picture they painted, the more likely that I was to go ahead. And again, that was my purely decision. I understood that and took that risk on board. And I'm not blaming anyone, that is my decision. At a government level, it's really important to remember that in the review of the biodiversity legislation in New South Wales by the Independent Biodiversity Review Chair, it was chaired by Dr. Neil Byron in 2014, he stated that we are not aware of anywhere in the world where long-term conservation of historical, cultural, biophysical resources has been successfully achieved through exertion of coercive powers of government. Now, that's a really important fact because, once again, from a farming point of view, we think it's really, really important that farmers are part of this, not just on the outside. Regarding the integrity of the scheme, it's essential that adequate resources are spent with the landholders that are involved with the offsetting scheme to ensure the maximum benefit of the scheme is achieved, and any resources shouldn't be limited just to the participants, but also should include interested neighbours. If it's properly run, the offset scheme will allow government to restore some trust that was lost when the focus on outcomes was replaced by process. Both the state and federal government have moved away from where landholders and have moved away with working with landholders to a more regulatory focused approach. Again, a classic example of this is New South Wales vegetation mapping. From the very start of the process, New South Wales farmers, represented including myself, warned the governments that the maps would have very visible value and would increase the distrust of government. New South Wales farmers warned the governments that the maps would not be accurate enough to provide real outcomes, instead of the tens of millions of dollars that would have been better spent on programs like this offsetting scheme. Unfortunately, the millions were spent on mapping with no outcomes. An example on my farm was a molasses tank and a willow tree mapped as koala habitat. African lovegrass and Chinese elm trees were mapped as native vegetation. If governments could offer landholders reasonable assistance with environmental works, that would be without the negative consequence, that the outcomes would be far better. And thank you very much for your time.
Thank you very much, Mr. Atkinson. We'll now go to questions and we'll start with the opposition, Ms. Penny-Sharp.
Sure, thank you. Thank you very much for coming in and thank you for your submission. I wanted to just ask you first about some aspects of the submission from New South Wales farmers, if that's all right. You make the point in your submission that loss of biodiversity due to land management can be beneficially offset through a combination of social and economic regional benefits as well as strategic environmental protection. What do you mean by that?
What we're meaning by that is that, so at a regional level, instead of focusing solely at the individual farm level, if we look at the regional level, we're adamant that we can get a much better outcome than just simply focusing on the one farm, and we need to look at our regional base to maximise the benefit to the community.
So in terms of offsetting, you're talking about, you might be able to, some lateral thinking in relation to where the offsets are found within a given region. Is that what you mean?
Absolutely, absolutely. Like in the northwest of the state, there are a lot of landholders that have got land that they would, quite happily involve in these schemes to ensure that they can manage, they can have other areas that can be developed.
But when you say, okay, I get that part of it. But when you talk about social and economic regional benefits, is that separate to offsetting? I mean, are there other things that you think that money should be put into that would be better than direct environmental offsets? Is that what you mean?
No, look, it's a combination that we think that the offsetting program by itself has some significant benefits, but also the fact that by having a scheme that enables a balance there, but with the development of some areas, with also the retention of other areas, will have community benefits. So, and the example there is if the farm is financially more viable, well then they can contribute to their local community, and that makes a real difference.
When you say contribute to their local community, what specifically do you mean? I mean, look, the reason why I'm asking is that, the biodiversity offsetting is supposed to be about, well, we're losing habitat for whatever reason, development or, on-farm work or any of those things. And the idea is that you then replace as much as you can, like for like, or you look at, increasing the amount of area elsewhere that is protected. I just don't quite understand whether you're suggesting that that process could be used for other things that's not directly about finding similar habitat elsewhere that would be protected.
Yeah, look, I'm struggling. Once again, I'm sort of struggling. So your question is that. Yeah, I'm just trying to make clear what the question is. Sorry, I'm trying to.
Well, I suppose. Well, my question is: are you suggesting that biodiversity offsetting isn't just about protecting habitat? So habitat's going to be cleared and it's offset elsewhere. My reading of the submission suggests. My reading of it is, and this is what I'm trying to explore, is whether you think when you talk about and you mention it's mentioned several times in the submission, augmented by socially or economic valuable projects. I'm just asking you whether what you mean by that is projects that are not related to preserving habitat elsewhere if it's cleared.
No. Again, my reading of that is the fact that the offsetting programs can provide a valuable resource for the local community.
But they can be used more regionally. No, that's great. Thank you. I'm not trying to be tricky about it. I just was trying to understand what that meant. Thank you for that. I wanted to ask you about. You said in your opening statement about places that have got koalas on their property, and I know most farmers are actually usually pretty happy about that. And you made the comment that it should be rewarded rather than subject to further regulation. How do you think that should work?
Yeah, there's no simple thing, but I suppose the simple thing is the fact that at the moment, the real problem with that is that, again, under the current methods, the koala mapping, for example. So if a farmer gets identified to have koalas on their land, instead of being offered some type of incentive to a reward, at the moment, all that is offered is greater regulation and a loss of property value. And so it's really important that the negative of having koalas is removed and is actually incentivised.
But isn't that what the Biodiversity Conservation Trust and other things are supposed to be about? The idea is that if you identify them, then you're eligible for these programs, which then means you can get some other income that supports the restoration and care of that habitat.
A perpetuity.
Yeah, that's right. And that's what we're trying to point out. That schemes like this that do benefit folks that do have the high value, the higher value stuff. That there is a process for them to be rewarded, not just further regulated. That's where a scheme. So,
are you really talking about the sort of land clearing regime versus the sort of biodiversity conservation scheme?
Yeah, not so much one or the other. We're just saying that for a farmer that just that has got a particular area, and she's identified that she's got some koalas. What we're trying to do is make sure that they are rewarded. There is a reasonably simple process in place to reward them for that, and to encourage further adoption of practices that will encourage native vegetation.
I think there's furious agreement that we want to make it as easy as possible for landholders to be able to access these schemes, because they are clearly, in your experience that you outlined in your opening statement, it clearly indicates that there's some real problems there and a lot of uncertainty, and it makes people hesitant to sign up.
Yeah, look, the greatest problem is, and koalas are a really good example, is the fact that for a farmer, it is a really two-edged sword. Like everyone that I know loves the idea of having them. if they haven't, that's great. But they really don't want to put their hand up, because then they're going to get identified and then they're going to have more issues to deal with. And so they just sneak under the radar and don't tell anyone. And that's not a good outcome.
No, it's not a good outcome for anyone or for koalas. Yes, I agree.
That's exactly right.
That inquiry.
I agree. Thank you. I mean, I know others have got other questions. I might just ask another one. I might come back to it. I wanted to, your submission's extremely critical of Part 5A of the Local Land Services Act and the changes and, the work of the panel in relation to native vegetation. And you indicate that there's only been one successful application in more than 4 years. Can you just unpack that for us a bit? Give us a bit more information.
Yeah, so again, I'm sure the committee does have a reasonable understanding of how this particular, but what this is meant, that particular part of the reforms was meant to provide landholders with a way that in areas where they might have significant amounts of native vegetation already, and they would like to develop a small, a reasonably small part of it. So they might have, for example, 8,000 hectares. Example, and there are plenty of places in the far western that is like that. They have 8,000 hectares of vegetation, and they may want to develop 1,000 hectares of that because it's to go into cropping, just because it's much more productive and much more profitable. And they would have to go through that particular system. Now, the rules under that particular system make it absolutely you couldn't afford to do it. As in the offsets. Most of the offsets you would have to tie up at least 8 to 1, and you would have to pay into the BCT for the species that you have destroyed. Now that makes it completely unworkable for farmers, and given the fact that in those examples they've already got significant areas of native vegetation and they're just expected to keep them for the community good, and there's no avenue for them to go down a way of improving their long-term viability. And that's where there was frustration from, and again, it really is it is quite a unique position. It doesn't apply to very many parts in New South Wales because of the development that's gone on, but for the farmers that are in those situations, they are enormously frustrated that they look around and they say, we've got 90% of our farmers' native vegetation, we want to improve 10% of it, but we just can't. And there's no real way to do that. And so there's just frustration that there's no real avenue. Again, for people that have got significant areas of native vegetation, that's really, really frustrating.
I might just hand over to I might come back to you. Thank you for that. That's helpful.
Sure. I think Mr. Justin Field has a few questions.
Right. Thank you, Chair. I might go to you, Ms. Doherty, if I could, in the first instance. Do you think that mines should be able to pay into the BCT instead of themselves buying offset sites or directly engaging with the market?
Yes.
Is he?
There's a real concern that the BCT has taken a really long period of time up until now to acquit offset obligations that it doesn't have the ability to not take on. If someone wants to pay the fund, they can. So we can have a situation where the impact occurs up front once the project starts, a mine or whatever, but those offsets not even be identified and found and acquitted for some period of time. In the instance of a mine, these are very high value projects but a relatively constrained space. Wouldn't it improve the integrity of the system to, at least for those projects, have them purchase the offsets themselves?
I think it just depends upon the individual project, and some projects will still probably purchase their own offsets, and it depends on the individual circumstances of that project, where it is, what the concerns might be from the community and others. So I don't see why mines shouldn't have the same options as every other developer. We're not really any different. But individual mines will make the decision on the circumstances of their project about which avenue for offsetting is best.
Well, now I know a lot of the mines in New South Wales have offsetting obligations under a range of different historical programs, but you'll be aware, no doubt, of the Guardian story, which highlighted that a number of mines in New South Wales, primarily coal mines, had received multiple extensions to their requirements to deliver offsets under their approvals. Can you provide, I'm not asking you to provide specific comments on specific mines unless you can and are prepared to, but do you think that's appropriate that mines that are currently operating should be given multiple extensions on the delivery of offset obligations?
Look, I think there's a couple of things in this. So I agree. There are a number of projects out there who have had some delays around finalising their security for their offsets, and you know, I can't speak about individual projects. You know, they've got different circumstances. It kind of depends on what scheme they're assessed under, the timing. But what I can say generally is there are a couple of things. One, we need to be careful not to conflate security, so registering the offset on the title of the property, with acquiring and managing the offset. So you would be well aware that previous schemes didn't really provide a lot in terms of paying to funds, or it really was a requirement that mines go and secure their own offsets. And that is still the case today, because frankly the Biodiversity Conservation Fund is not an economic means of securing an offset for mining projects. We can't buy the credits on market because the market doesn't have enough liquidity in the type and number of credits that we're looking for. So mines are still going out, they're still securing their own offsets, and they have been doing that for a number of years. So, but I think we need to be careful. We need to recognise that security is a different thing from acquiring an offset. And you'll find that most of their offsets, most of them acquire them at some point during the EIA process, maybe shortly after. They might have bought them before they even commenced their project approval process, because it's a way of reducing your risk, and when the properties are available, you need to buy them. So it is, it's not unusual for companies to have banked land ready for projects. So that's a really important thing, and that most of these projects that you're thinking about and that are being raised, they're legacy projects. They already have offsets that they own. They're usually owned by the time the project's approved. There are conditions in their project approval around the management of those offsets. They're required to provide a biodiversity management plan, and then to manage in accordance with that. They're required to report on their offsets. They're subject to compliance activities by the Department of Planning. So I think that's important to understand, that the actual security provides for the long-term protection of that offset, but it doesn't mean that the offset isn't in existence and being managed.
Sure, but the implication of that is that they haven't, in most instances, haven't been signed off as delivering the biodiversity obligations, i.e. the VCT may not have accredited it as delivering against their obligations, or it might not have been deemed to have been rehabilitated to the degree that it was expected. Is that more likely?
Well, we're just talking about offsets, we're not talking about rehab, so we're just talking about offsets. And what's in
no, I mean mine rehabilitations, though. I mean, some states, in some cases, the offset sites restorations are clearer word, yes, but that's the issue here, right? There's land's been acquired, but we're not delivering the biodiversity obligations at this point.
No, that's not right. So land has been acquired in the case of pre-biodiversity offset scheme projects, which is basically every mining project. That land is acquired. When you have that land during the EIA process, the mines undertake an assessment of that land during the EIA process. That assessment was part of a submission from OEH, now EES, so they will have assessed that land and verified that the values were there that were required to meet the impacts for the site. There would be, under their EIS, there would be an explanation about active management and other management they were going to undertake, but also a commitment and an approval condition to provide a biodiversity management plan. And the biodiversity management plan sets out how they are going to actively manage that site. And all of that happens pending any security being finalised. The security puts into place an agreement which reflects what the proponent has said they would do during the during the EIA process and through the biodiversity offset management plan.
Yes, but when you say security, you mean effectively, one example might be the BCT accrediting that as a biodiversity offset site and establishing the in perpetuity agreement, right? That's what you mean by security.
Yes. Or
why haven't that? Why
legacy sites much more likely to be a conservation agreement? So, you know, there are very few BSAs that have been created at this point. They are created under the biodiversity offset scheme. Those are coming through probably in the next year to 2 years. But at the moment, we're still largely dealing with conservation agreements and with legacy projects. So it's important to understand that. And yes, it is the security. It's the thing that prevents the offset from being developed in the future. It's not the ownership of the offset. And it's not on its own the management of the offset, because the management plan, the biodiversity management plan, provides for the management of the offset even before the agreement is finalised.
What is the delay on the security though? What's being said to me is that often, you know, whoever's the appropriate assessor goes out there and realises that that site might not be delivering the expected outcome, or the management plan, despite being in place, may not have been delivered on, and there are disagreements about the adequacy of the site, which is slowing the process of finalising the security. Am I wrong? Are the people who are telling me that?
No,
right?
I think the biggest problem has been really the churn, the regulatory and the policy churn around offsets in New South Wales. So for mines in New South Wales, we've probably been through it a bit more than other types of developers, because in 2014, the government brought in the biodiversity offsets policy for major projects. And that policy required mines to use a biobanking agreement to secure their offsets. So traditionally, we've been using conservation agreements. We were transitioned to using a biobanking agreement. There was some delay there because there were projects which simply hadn't been assessed using the BBAM. If you've not been assessed using the BBAM, you can't apply a biobanking agreement. So there was a delay there while there were negotiations with the government about what to do about those problems, and largely those sites are still have used conservation agreements. And then within 2 years of the major projects biodiversity policy being released, we had the commencement of the consultation around the biodiversity offset scheme, and it was very clear that the biobanking scheme was going to disappear, that biodiversity stewardship agreements were going to replace biobanking agreements, that we were going to have a new assessment methodology. So the BBAM was replaced with the BAM, which is significantly different. You need to have a BBAM assessment of your offset in order to, a BAM assessment of your offset in order to apply a BSA. So over the last, since 2014, there has been this really significant churn. There have been delays where people have stopped because it's clear that there is going to be a new type of security that's going to be required. So there's been a slowdown. Let's stop. Let's reassess what we're doing. Do we need to do this new type of security? Frequently told that we'll have to do it, and then backtracked to a different type of security because it can't actually be done. So that's the background to a lot of these delays. The other thing that's really important is that we've had a change in agency as well. So in this period of time, since the legislation commenced, the biodiversity conservation legislation commenced in 2017, we've had a whole new agency, the Biodiversity Conservation Trust, who've been set up who deal with the applications for these agreements. So they deal with conservation agreements, they deal with BSAs, and so they've had to start from scratch. They've had to completely, upskill, bring on people. There have been delays with them. There's different expectations that we're now having to meet as well. And I think that has led to some back and forth between mining companies who've been using voluntary conservation agreements and the BCT, who are now asking for have different management. Before that, it was OEH who both assessed the mining company's project and looked at their offsets during that EIA process, and then also were responsible for assessing and signing off the VCA. So now we have different agencies, and it has led to some complications.
Chair, if I could just one last one.
Sure.
Ms. Dolly, I've put these questions to the government around the delivery of mining offsets, and the most recent answer I got back, of the 41 projects approved in the past decade, and this specifically related to coal mining projects, 1 did not require offsets, 14 have not yet triggered the requirement for offsets, so they mightn't have commenced that part of their project. So the ones that have, 17 have, and they say, substantially finalised in perpetuity security arrangements. They don't specify what substantially finalised mean. And 9 have land set aside, which is being approved in accordance with individual BMPs, and further work is underway to secure the land in perpetuity. My reading of that is not one of the 41 coal mining projects approved in the last decade have secured the offset obligations that they have. Am I reading that?
I think that's wrong, because I know there are conservation agreements approved. So I don't know. You're throwing the figures at me. I don't know. I can, you can ask the government again. They'll be there tomorrow. But my understanding is I know members who have signed off conservation agreements. So I'm not sure what date you've got that information on, but I don't think that can be right.
I got that last week.
Did you? Okay.
Okay, thanks, Jeff.
Thank you. I will ask you, yes, Ms. Doherty, a few questions about mine rehabilitation, if I can, being used as offsets. Is that an increasing incident now that more and more offsets are being used? Sorry, mine rehabilitation is being used to offset mines. Is that recent in terms of the increase in that happening?
Can I just be clear about who's speaking to me? Is that Ms. Sharp?
Sorry, no, it's the chair, Ms. Fairman.
Okay, sorry. I can't see.
Sorry.
No, that's fine. No, look, I know, and I've read the submissions of some of the environmental groups, and I've read their evidence in their transcript, that there seems to be, there seems to be this sense that there is more rehab use. I would say no, actually, it's probably going to be the opposite, that probably ecological rehabilitation as an offset is going to be less likely to be used now than it has in the past. So obviously the biodiversity offsets policy for major projects, and now the BOS provides specifically and explicitly for rehabilitation to gain offsetting credit. But prior to those schemes, there was always, part of a mine's rehabilitation would be part of their offset package. So it is something that's been credited, but perhaps not explicitly, for a number of years. But I would say that under the biodiversity offset scheme, it's less likely to be used. So what the biodiversity offset scheme does is it sets up this very robust way of assessing what offsetting credit can get for ecological rehabilitation. And it's really significantly discounted. So, of the 4 elements which can generate offsetting credit, security, averted loss, standard management and active management, you can only get credit for one of those, which is the active management component under the ban. So it really is quite significantly discounted. So that's the number one thing that I suppose you need to take into account when you're thinking about whether this is attractive to proponents. The other thing is that you are going to have to, sorry, I just need to...
But if there's, just to jump in there though, so if there's clearing of a particular vegetation type that is going to be extremely hard to offset because it's so threatened, then it would be attractive at some point for the mining company to have an offset obligation, which is rehabilitating a mine site, wouldn't it? And I understand that some companies have got sorry, I'll just if I just finish, and I understand that some mining companies have the ability to offset the same mine, say 20 years down the future. Is that correct as well?
What do you mean offset the same mine? So
offset the mine for which the clearing that is going to take place as a result of a mine. I'll give you an example. I understand that Glencore's Mangoola mine will be offset, the habitat destruction by that mine will be offset by the future rehabilitation of the same mine site. Is that correct?
That you will impact on a mine and that you'll be able to get some credit for the ecological rehabilitation you do on that site? Yeah,
the habitat destruction caused by the construction of that mine, that you will be able to offset that by rehabilitating in some part, whether it's 20%, 30% of your entire total offset obligations, but that that the future rehabilitation of the same mine site will be counted. Is that correct? Is that able to happen?
Yes, that's it in a nutshell.
So from the same mine site. So just, are there examples?
Well, different mine site. I don't understand.
Sure. Okay. So are there examples of successful rehabilitation of, for example, intact woodland communities in terms of mine rehabilitation? Has that been proven yet that can occur?
Can I go back to answering your first question? I would just like to tell you, I would like to explain to the committee why I think that it will be less. So I covered off on the fact that there'll be, there's a reduction of credits. Also, you have to undertake what is a very difficult type of rehabilitation. So we acknowledge that, and this will come to answering your next question as well. You also have to demonstrate that it's feasible and likely to succeed, which again, Chair, comes to your next question. But also there is a significant risk that proponents have to take on board. So they take on board the risk that at the end of 20 years, that they won't be successful, that they won't meet their completion criteria. And that is a risk that they need to take on. And because of that risk, they have to not only undertake their rehabilitation and take the expense of undertaking that rehabilitation, but they also need to provide a bond which covers the costs of securing an offset if they're unsuccessful at 20 years. So effectively, you could end up paying twice for that rehabilitation. And I think all of these things, these four things that I've outlined, they do make it relatively unattractive. And they do mean that it's really only likely to be, big operations who have very sophisticated rehabilitation practices and who have been successful in undertaking this type of rehabilitation in the past, who will commit to it. So, I would very much say that it will be less rather than more. Then to your next question about research.
Yeah, we've just got 2 more minutes until,
Yeah, okay, I know. Fine.
I can put some questions on notice. I'm just conscious government has asked questions. So, Mr. Mallard.
Ms. Doherty, I'm surprised to hear that rehabilitation of a mine site is a valid offset on the project. I would have thought that would be an obligation for the destruction that a mine causes. Is that a historical situation that's coming forward from previous regimes of, approvals for mines that it's an offset, or is that embedded in the current policy of the government?
It's part of the biodiversity offset scheme.
The current one, yeah. Okay, and to your knowledge, how many mines have availed themselves of that option? And you said before it could be 20%, 30%. Yeah, of the a component of their offset being the rehabilitation of the mine in 20 years' time of the site.
I don't know.
You don't know. Could you take that on notice, maybe?